application is given as 28th of February, whereas the order is actually 20th. So,
Oh, 20th.
yes. So I think now that the order is uploaded, I'll have to file a clarification, I think.
Simple modification.
Yes, I'll just file. I'm just seeking a lordship. So I'll file this application, then lordships can do the correction accordingly.
We'll make a correction if today comes, today only, or if it tomorrow.
Tomorrow.
But now the question is, I'm not taking any mentioning matter.
Right.
So just approach the registry so that the matter can be listed
Yes,
by
I'll do
today.
that. I'll do that.
On production list or by tomorrow.
Bye. Extremely grateful, madam.
May I please? I bet my mention item number 20, 29, 30, madam, out of same case.
29?
22, 20, 29, and 30. Out of same case. Medical report.
120.
Eh?
1,
20,
29.
30. 3 meter. 3 meter out of same case from this school. Medical
Out
report
of
was called.
same case diary.
Yes, Lord. Up to that CD and medical report was called from. Perhaps medical report knowledge.
My lord, here CD received, my lord, without the medical report, my lord. And my lord, one Suhail Anam, he was interim was granted, my lord, on 19/3, my lord. His statement is not available.
So you want to call for the
Up to date, my lord, up
with
to
the
date, along with
medical.
the statement, my lord.
With the medical.
Medical.
You all are on interim.
Yes.
Interim, all are in.
Administrative Gauhati learning council for the petition. So we're done, yeah. CD receipt, but it is submitted by Mr.
29.
Sharma that CD is not updated. And the one of the petitioner's statement is also not available in the case diary. That apart, the medical report is not yet received, which will be necessary for the disposal of the bill paid applications. In view of this, let the updated case diary be called CDB return. Stop updated case diary along with the medical report be called for.
Statement of one of the statements, Suhail Anam.
Yes, I have already. Interim be continued till next date of listing. When it can be listed?
Well, that's for 29th, my lord.
29th of April?
April.
Yes, April.
Deep level.
May it please your lordship.
Yes.
Lordship, I beg to mention the urgent listing of an interlocutory application we have filed yesterday. Actually, your lordship, on 23rd March.
Make a mention before either before court number 8 or before registry.
Lordship, this court passed the order on 23rd.
I have passed the order, but it will come before this court only. But
Yes, sir.
we are not taking any mention in that.
Okay. Obliged.
May I please, sir? I beg to mention item number 19, my lord.
19.
19.
Yes.
Perhaps CD is not there.
Yeah, but there is interim. You are sent for update.
CD not updated, CD not received. Issue reminder. Interim be continued till next date of listing. Yes, when it can be.
My lord, 27, my lord, 27 April, my lord.
Your interim will be continued 27 April.
Obliged.
May I please, lordship? I beg to mention item number 26.
20.
26. Up to date case diary was called for, lordship.
Yes, Sharma. What is 26? 26 and 27.
27, my lord. CD not received, my lord. Updated CD was called. Updated CD was called for, my lord.
26. You are on
Vic.
entry.
26. Yes.
But what about
उसमें ना जो
26?
कबर्ड है कबर्ड में सबसे पहले जो रखा हुआ मेरा अकाउंट है बच्चों के रूम में
What are you saying? Connect to you. Huh? Who? Boy, tell us. Now, who listen? One thing. Last time, am I here? Council pull us here.
कौन तो? नहीं नहीं अपना क्या 27 नहीं 27 oh नहीं CD नहीं updated CD नहीं इंटे में रसे तो है बिहेव पिछले कोई
My brother is like, not like a majority.
Yes, I'm asking whether 27 also there on interim.
my lord
No, you are on interim on 27
Yes.
also. Same order. You are not receiving the updated one.
updated CD
Updated case diary not received. Issue reminder. interim be continued till next date of listing, list accordingly when deputy council available.
29th, my lord.
29/4. Apply.
Yes.
Obliged.
Problem.
May it please your lordship, I beg to mention item number 23, lordship. CD was called for, but was not.
Item
received,
number?
lordship. 23. 23.
My lord, CD not received, my lord.
Are they on interim? No,
No, my lord.
you are not on interim.
Interim
You are
is there,
not
lordship.
interim.
Interim is there, lordship.
Interim is there?
Well, it is not written. We'll have to check.
My lord. 23. In the earlier occasion, my lord, report was called for whether any case registered or not, my lord. Thereafter, case was registered, one case, but CD not available to him.
We have to go to the person.
Interim is there.
Interim is there, my lord. Interim is no?
City not
Well,
received. Issue report. Interim be continued till next date of listing. Yes, when it can be.
My lord.
When it can
April,
be.
my lord. 24th, my lord. 24th April.
24th of April.
My lord. Much obliged.
May it please your lordship, I beg to mention item number 21, lordship. We want to not praise the application, lordship.
You don't want to press the petition? You are MS?
A Mohan Doc.
I heard MS A. Mahanta, Tilane Council for the petition. Also heard Mr. B. Sharma, Tilane additional PP appearing on behalf of the state. It is submitted by MS Mahanta that as per instructions of our client, he doesn't want to praise the petition, but accordingly praise withdrawal of this prayer allowed. Okay, it will be disposed of on withdrawal.
My subject.
May it please your lordship. Lordship, I beg to mention item number 11, lordship. Lordship, in this matter, due to some personal difficulty, lordship, we cannot conduct the matter today, your lordship. And moreover, the CD has not been received, I guess.
My lord, CD in the earlier occasion, my lord, CD was received, my lord, and the return CD, due to the, my lord, they have not taken contact. That's my call for CD.
Lordship, can it be fixed on
It is
27th?
requested by London Council for the petition. Matter is that further it is submitted by Mr. Sharma, the learned additional PP that CD not received. Also issue reminder for the CD. Yes, when it can be.
27th of April, lordship. Lordship, I am in interim, lordship.
Was there any interim?
Yes, yes.
In this investigation is still continuing, I think.
My lord.
Is it a charge sheeted case? No.
No, your lordship.
No, no, no.
Investigation was
Stay is
stayed,
there,
your lordship.
stay.
Stay is there.
Stay is there.
Yes, sir.
Investigation. Acha?
Lordship, on the same facts, 2 FIRs are there. That's why, lordship.
27 interim be continued till state months.
Obliged, lordship.
May I please your lordship. Lordship, I beg to mention for listing, lordship. There is a criminal revision, lordship. Long
Make a
pending-
mention before
No, no,
vote
no,
number
vote
8.
number 8.
Mid lordship. Item number 22, lordship. Yes, that is not received, lordship. Third occasion, lordship. Last 3 occasion case that not. There is no
Yes,
intake.
is
also.
any information from IU?
My lord, in the morning also it was, my lord, from our office it was called to the, my lord, officer and says, my lord,
Reopen.
but they are, said that I will inform later on, my lord, after some time, my lord.
For
If
time
time
being.
comes, no?
By statement.
It's sorted later.
You are not on
He
interim,
was-
I think.
No interim, lord.
She did not receive. Issue reminder.
Oh, I think then,
Fine.
by state, 21 state মানে দিতো ন?
আহিব জানো কালি? No, no, because
কি নামটো ন? 109 আছে।
yes, Sharma, can it be on 2nd or 1st of April or when?
My
Can it
lord,
be expected?
My
2nd
lord,
of
my lord.
April?
second, my lord.
Yes.
Obliged.
May I please, your lordship? Well, with due respect, I beg to mention item number 32, my lord. My lord, matter may be adjourned for the day and fixed it on 20th of April, my lord. When
Item
it's a
number?
criminal April, 32. There is a I for bail, my lord, is pending, my lord.
That's why it is on in order column.
Yes, my lord. Can it be on 28th of April?
The request made by the council for the applicant. Matter is adjourned. Yes, when you are saying
28 April.
2/8,
Yes, my lord.
list on 2/8.
Much
Okay,
obliged.
by listing it on page.
Lordship, I beg to mention item number 36, Lordship. Lordship, this case has been engaged to Senior Counsel K.N. Chaudhary, Lordship. He's having some personal
Who has been
difficulties.
engaged?
Lordship,
Your engaged counsel is
Senior Counsel K.N. Chaudhary.
Ken Chaudhary. His name is not here. Why?
Essential, but it has been
Oh, my.
engaged to K.N.
We
Chaudhary.
have already engaged.
Yes, Lordship. He's having some personal difficulties today. Lordship may take up the matter after review petition.
The request made by learned counsel for a petition matter is adjourned. It is also submitted that senior advocate Mr. Ken Chaudhary has newly engaged in the present case. Prayer allowed. Yes, you are submitting anything? It is a matter of 2012, in fact.
Yes, Lordship. Lordship may fix the matter after review petition, Lordship.
Wait. It's 28 is a hearing day, so we are fixing it on 28. Was there any interim?
No.
28 of it.
May it please the Lordship, with the consent of the other side, I beg to mention item number 6.
Item number
6.
6.
I am for the petitioner in this case.
You are for the petitioner.
Yes. For the respondent.
You are for the respondent. Yes.
Yes.
With the consent of the other side, the learned counsel appearing for the petition made by an adjourned. Read out. You want any fixed date or after 2 weeks?
28th April will be fine.
2/8.
2/8. It's a hearing day.
Hearing day, we know. Can it be? He is saying on 30. It's also an hearing day.
Obliged.
May I please, Your Lordship? In item number 7, TCR was called for.
Item number
7.
TCR
TCR was called for, but that was not reflected in the cause list, my lord.
Item
My-
number 7.
7.
Just a mere one plot. So we have not received.
So, my lord, another date may be fixed. My respondent side is available.
You are for the respondent. Heard the learned counsel appearing for both petitioner as a respondent. From the office of the previous that the scan copy of this year is not yet received. Issue reminder, raised you will do the needful.
There is an interim order, my lord, there.
Please see matter accordingly on 30 April. Interim be continued till next day.
All right.
Three zero. Forty along with
28.
in both 40 and 28 you are appearing. Both the matters you are appearing. In both 40 and 28 you are appearing.
Yes.
Yes, sir.
In item number 28, CD was called for, but
28. Yes, in 28 it was an AB CD was called for it.
My lord.
It's not received.
My lord, charge sheet submitted. In both the cases.
Charge sheet submitted.
My lord.
Okay. So are there interim?
no one.
No, my lord.
You are not on interim.
No, my lord.
Now. Yeah. You are Mr. Ahmed? You are Mr. Ahmed?
Yeah,
Or Mr. P. Ahmed, attached to the learned counsel for the petition. And also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. It is CD not received, however, it is submitted by Mr. Sharma that case has already been charge sheeted by CS number, yes?
I charge sheet number 9/26, dated 23/3/26.
9/26, so and so, so and so.
Well,
In view of above, the petitioner is hereby directed to appear before a learned trial court below with an appropriate application for bail, which may be considered in accordance with the above observation, the present applications.
hearing someone?
And 28, how many days you were in custody? Sorry,
40 days,
40 days.
40 days. Can you consider?
Cannot consider
My
these
lord.
days.
103 is there. 103.
Yeah.
Heard Mr. P. Hamid, the learned counsel for the petitioner, also heard Mr. B. Sharma, so and so, Hill. Case was fixed for case diary, but it is submitted, so and so, so and so. However, it is submitted by Mr. Ahmed that the accused petitioner is in custody since last 40 days, and considering his length of detention, the bail prayer may be considered. As the case has already been charged, the petitioner is hereby directed to appear before the learned trial court below with a regular application for bail, which may be considered in accordance with. So and so. I have mentioned that you are in custody for 40 days. That may be considered by the learned trial court below. Let us see.
Right.
Otherwise, we have disposed of it.
My lord.
My lords, with the permission of your lordship, may I mention item number 38 if possible, my lords?
Item number?
38, my lords.
Yes.
Rakesh Chandra Maldas. My lords, this matter is not been reaching since past 3 dates, my lords. My lords, if possible, my lords, may time fix it today. We are ready to argue, my lords.
No, if time permits, I have in the morning hours, I have already informed you. If time permits, matter will be heard. But if
My
time
lords.
permits, okay. Because it is the last matter, there are many matters in admission column, also hearing matters also. If time permits, matter will be heard.
Yes, my lords. My lords, actually, what is happening that he's been into custody for last 3 years now, and
No,
his suspension
yes,
of
I can understand.
sentence.
But if time permits, if matter reaches, then it will be heard. That's
Please, my lords, please.
one ambition. It also. Oh.
May it please your lordship.
Yes.
My lord, 482 application. What happened in this case, lordship is aware about the facts here. The fact is, lordship petitioner was detained in custody in connection with the case, and he was there in judicial custody for a considerable period. Thereafter, considering the fact that his father is very serious and considering the detention, lordship was pleased to allow even. This is the order, lordship. Now, the moment he stepped out, lordship, the Mongol police also harassing him and saying that vehicle in position. Now, but they are not disclosing who has filed FIR or anything. So at this point, lordship, he has made all endeavor to know who is the complainant on what basis, but they are not disclosing. So that is why, lordship, this application has been filed on the on anticipation of being arrested. TD entry.
And which case? What kind of case? What nature of case it will be?
Same nature, my lord.
Same
nature, my lord. Taking the rent, vehicle on rent, my lord. They are pursuing the death rent, my lord.
So, lordship, may call for a.
Now you are for this in which
Mongol PS.
Oh, it is a Mongol.
My lord. No. Only
We
report.
call for the
Report, my
Yes,
lord.
only report, lordship.
Hard MST Som, the learned counsel for the petitioner, also had Mr. B. Sharma, the learned additional PP appearing on behalf of state respondent. This is an application under section 482 BNSS paying for anticipatory bail. In a case in connection with anticipatory bail, as there is an anticipation of registration of any case under Mongol PS, the petitioner is the police personnel is harassing the present petitioner, and hence the present petition has been filed seeking to clear this bail. Next further, Mr. Sharma, the learned additional PP, submitted that he will call for the report may be called from the concerned police station as to whether any case has been registered against the present petition. Building petition. In view of this, later report be called for from Mongol police station as to whether any case has been registered against the present petition. When it can be fixed?
30, lordship.
31st. 31st.
31st. 31st.
Obliged.
May I please your lordship? But it is in application 482. My lord, I take your lordship page 14. My lord, I am the guarantor of his own car, which was purchased from the Silchar. Though my lord, name of the dealer is wrongly given, Rockland is from Shillong, but Mahindra showroom is Silchar. My lord, I being a financial guarantor of this car, my lord, after 45 days, he has lost the affair. After 45 days, that I have snatched away the key of the car and taken away the car. My lord, what happened actually, at the time of guarantor, he took some money from me because initial deposits, the money is required. But when I asked for return, there is a tussle. I said that I will surrender your financial guarantor. Then he lost this affair. After 45 days, that my key of the car has been taken away from my driver. Now, my lord, case has been registered against me, though 304, that is, and my lord, 308, my lord, that is, my lord, punishment is 3 years and 7 years, my lord. My lord, I am covered by the honest command. No notice was served upon me, my lord, under 35. So, my lord, I will appear and I will explain the reason why, how it has been happening, my lord. And why, after 45 days, FIR was lost, there was no explanation.
FIR is lost on which date?
FIR is lodged, my lord, on 16/12/25. Occurrence took place at 1/2/25.
Occurrence took place 16.
Occurrence was 16/12/25. After 45 days. And there was no
Where
explanation.
from you are saying after 45 days, I could not follow you.
Beg your pardon?
Where from you are saying that it is after 45 days? Just I'm building the record. It is the FIR was lodged on. Acha, FIR was lodged on 1/2.
1/2/26.
Acha.
And occurrence took place on 16/12/25. That's why delay of 45 days. I ought to have been served with 35 notice. That was also not given.
Not necessary, is that?
Necessary, brother. Can you ignore the ordinance
It is
command?
the AB, my lord.
AB, yes.
AB, my lord, not necessary at present, my lord.
No, that's why. That's why. Had there been any
No, Anas Kumar is on when arrested, my lord. If he was not
before arrest, not
But
arrest.
it is the
Before arrest.
at present, it is not.
Why had there been any material came out against me, they could have served me, they could have called me.
Lordship, kindly page 14, my lord. FIR, my lord.
Yes, FIR I have brought to notice of the honorable court. I am a guarantor of the vehicle, financial guarantor.
Yes, sir.
My lord, thereafter he has taken the key and
Yes, that is the allegation after 45 days. Had I been done it, why you have not done it immediately? That I have taken the key.
CD, my lord, at this stage, my.
I will appear, my lord, I will give you a statement, my lord, how it has been come up, man.
Also heard Mr. Bishop. Disseminate. This is an application.
Finance guarantor is Tajuddin, my lord, from the FIR itself. Although learned colleague has said that, my lord, he is the financial guarantee, my lord.
No.
Page 14, my lord.
My lord, my friend is, can you
Driver.
read it properly? You see, Tajuddin and Salimuddin, I am Salimuddin, are financial guarantor.
One is submitted by Mr. Business that I was the financial guarantor of the car, where when it were the guarantor of the car, and the allegation is brought against me, against the present petitioner, that he snatched the key and they also demanded extorted rupees 2 lakhs from the informant. But surprisingly, the incident had happened on 16/12/2025. However, after 45 days, that is on 1/2/2026 only, the FIR has been launched. Further, he submitted that till date he has not received any 35(3) notice from concerned police station. So he is ready and willing to appear before the IO and to cooperate in the investigation. Next point, Mr. Sharma submitted in his report that there is an allegation of snatching and extorting of money from the from the informant, and hence he submitted that the case diary may be called for to know the actual fact of this. Next point, the submission made by
And court below also rejected your prayer in the earlier manner.
Yeah, that's why I have come here.
So considering the
I have not suppressed the matter.
the this court is of opinion that one opportunity may be given to the present petitioner to extend his cooperation in the further investigation. So and so. Hope you will be under interim protection and appear before the IO.
Develop.
When it can be, what?
My lord, CD on my lord 28, my lord.
20 or 28?
28, my lord.
Yeah,
Oh, 28 foot.
thank you.
Yes, what is it? 50?
My lord, CD not received, my lord.
My lord, in this case, what happened? 45 days I'm behind the bar. There was an allegation of that I attempted to snatch, cheat hard. My lord, your lordship that day already read this FIR, my lord. 45 days has been taken, my lord. They failed to produce the CD, my lord, today. Statutory period is 60 days, my lord. And yes. My lord, FIR, your lordship, you find I paid 12, my lord. I tried to make the video incident and they ran away. The unnoted accused person caught by the local people. They tried to cheat me.
My lord, I am reading from the beginning, my lord.
Yes.
I was processing money withdrawal at so and so branch. 3 identified person approached me, and one of the 3 men told me that they had stolen with 1.5 lakh from Dimapur and tried to deposit the money, but the money could not be deposited. Later, one of them came to me and said that if I deposit the money through CSP account, they would give 25% to me. Meanwhile, I had already withdrawn 40,000 from my bank and came outside the bank, and the 3 men followed me outside. Outside, one of the men asked me rupees 3,500, but I refused to pay. At that time, the unnoted accused person tried to give me rupees 500 note to me along with some pieces of white paper in a bundle, and in return demanded rupees 3,500 from me. At that time, thinking that they were going to scam me, I tried to make video of the incident. Then they ran away. The undernoted accused person was caught by the local people and handed over to the police. That is the allegation, my lord.
Yes.
Undernoted person along with others, namely Jogi, tried to cheat me and
tried to cheat me.
Take rupees 40,000 from me, my lord. That is allegation, my lord.
No, that cheat me and to take 40,000 from him. By cheating 40,000, they want to take. But they have not taken anything. That was an attempt. So 45 days behind the bar, my lord. Enough punishment.
Yes, sure, anything to submit.
My lord. My submission is a lordship may call for short that my lord may be given, my lord. Last chance we will produce the case there, my lord.
First part of the FIR is very serious.
My lord.
That they have stolen 1.5
My lord.
from Dimapur, right to. But
later part.
but from an unknown person.
Bhanigura is there, my lord.
CSP account.
My lord.
25%.
Bhanigura is there.
Short date means when it can be.
My lord, from
Goalpara.
Goalpara, my lord. Sixth, my lord.
6.
April.
Statutory period will be over, only 5 days
No.
left.
No.
Only 45 days.
কি মানে 60 days আর বহুত কোন ordinance না
হ্যাঁ, এটা 60 days এর
ও
60 days, 45 days the whole year, 15 দিন আছে, 15 দিন আছে।
the second, my lord, we will try, my lord.
Second,
My lord.
he did not receive. Should-
May I please, Your Lordship?
Yes,
CD was
where?
called for my.
We have received the case diary here.
She did not receive, my lord.
My lord, out of same affair, another case is listed in court number 8, in which CD was received, my lord. Today morning I have checked, my lord.
Which date it was listed?
Today.
Today.
Today itself.
Oh, then okay, you can. Can it be bring today by itself
No,
or
we'll have again go through it, my lord. We'll have to go through it.
then what to stop?
Tomorrow, my lord.
Huh?
Tomorrow. Number 23.
Month.
Book number 8. Number 23. BA number 5.
Boko, thank you.
Yes, Sharma, what to do? Tomorrow, if it can be possible, if the order is released, then the CD may be returned. Otherwise, do I?
If it is rejected or then it will have to.
No, rejected. Question rejection is otherwise.
Right.
Oh, yes, if rejected.
My lord.
Then you want to say that it will be again
Again in
that
this
before
court,
that court.
my lord.
But that apart also, I'm just thinking. Suppose today is the fixed date, huh?
Today is being.
Suppose today after hearing the matter, maybe reserve may not be possible for the court to pass the order by
Right.
today itself. Let it be tomorrow the CD may return, then in that case it will be again difficult. So otherwise, can it be pass an order to place it before court number 8?
That can be also done.
That can be.
That can.
It'll be done.
But program এটা নেই।
হবো লাগে। CD is available. Heard Mr. R. Ali Dilanet counsel for the petition. Also heard Mr. P. Sharma Dilanet additional PP appearing on state response. CD not received. However, it is submitted by Mr. R. Ali that out of same FIL, one more case is pending before a coordinate bench of this court, wherein the CD has already been received and the matter is also listed today. As the case is out of same FIL, this court is of opinion the matter may be listed before the coordinate bench by today itself. Irresistible. Yes, case number
BA number 524/26.
524
Lordship.
oblique 26. 524, 26 or if you really PA number, man is pending. We have passed the order. We'll try to put the signature by today itself. We'll bypass it. It may be listed before that.
Today itself.
Today itself. Yes. Yes, 17. What is it? We received case diary.
CD received, my lord. After entering CS appear statement recorded. Please. In the earlier occasion, after the CD was called for, my lord, along with statement, my lord, she has appeared and statement recorded, my lord. She was the wife of my lord, well-known person, Dharmeshwar Roy, my lord.
Oh,
That is the case.
Allegation against the husband, my lord.
Several cases are pending against.
Subsequently,
Seven.
yes, man.
Mr. Roy is now popular.
Popular.
Now he's on bail, man.
He will do again, I think.
Oh, again, man.
Same. Heard Mr. T. Hussain, Dilanet counsel for the petition. Also heard Mr. P. Sharma, Dilanet additional PP appearing on behalf of state. It is submitted by Mr. Hussain that the petitioner is innocent. and she has not committed any such offence as alleged in the affair. However, after obtaining the order of interim arrest bail, she already appeared, cooperated in the investigation, and her statement is also recorded by the I. Your interim was granted on 10/7 or what?
Yes, ma'am.
10/7.
10/7.
10/7. So and so. However, she is still ready and willing to extend her cooperation in the further investigation of this case if she is provided with the privilege of the arrest. Next, Mr. Sharma, the learned additional people submitted in this regard that the petitioner had already appeared before the IO, her statement is recorded, and accordingly she is cooperating in the investigation of this case. Next, considering the submission made by learned counsel for both sides, materials available in the case diary and the conduct of the present petitioner, this court is of opinion that custodial interrogation may not be necessary for the purpose of investigation. In view of this, the order of interim pre-arrest bail dated 10/07/2025 is hereby made absolute with same terms and conditions.
Deeply.
Please, Lords.
Yes.
Sharma.
Yes, where it is it? We have received case diary here?
No, my lord.
No case diary.
No case diary.
You
CDN
are
report
in-
from IO also there. My lord, it is the matter of 2013, my lord.
2013 and you were granted interim most probably on 21/11. Quite old pending matter.
My lord, here in this case, Lordship, the petitioner approached before the Honorable Court, Lordship. Search sheet was submitted, my lord, in the case, Lordship. In the FIR, my lord, one name was there, Lordship. But in the search sheet, my lord, the person against whom the search sheet was submitted, Lordship, showing absconder, Lordship. That is not the petitioner, Lordship. But after submission of the search sheet, Lordship, a warrant has been issued from the learned, my lord, trial court. Then, my lord, police has come to my home
No, yes,
Lordship,
I can remember.
saying
have,
that you are that person.
disputed the identity.
Yes, Lordship. So,
Identity
as it
has
is
been
identity, the Honorable Court, my lord, directed to submit report, Lordship.
Yes, Sharma, why it is not receiving? Because the disputed.
My lord,
the
identity
identity
disputed.
dispute.
So that is why IU was directed to. My lord, my lord, visited the petitioner's home, Lordship, after order was passed by the Honorable Court, Lordship. But
then what he did?
Lord, IU verified everything, Aadhaar card and.
So you can simply file the report before us. That
Yes,
is only.
that report may be
Require the
submitted.
report only if
Yes.
you are not the person. So you should not be harassed unnecessarily.
Yes, Lord.
That is true.
Definitely.
That is
If you
our.
are not the person. Because it is not possible on part of this court to
My
make
lord, decide whether he is
decide the
the
identity
person
of.
or
That
not.
is why
because it
report
the
was
trial
called.
court
My lord.
can call for these things.
Yeah.
My lord.
But however, we had called for a report from the IOs.
CB also called for, my lord.
Yes.
Search sheet is
Heard Mr. M.H. Ahmed, the
Search
learned
sheet,
counsel for the petitioner. Also heard Mr. B. Sharma, the learned additional PP appearing on behalf of state respondent. Report not yet received. No, CD along with report is not yet received. Issue reminder with a direction to the IO to furnish the case diary along with the report on or before the next date of listing. When it can be listed?
My lord, after Bihu, my lord. 23rd, my lord. My lord, if it is search sheeted, my lord, then my lord, Lordship will have to call for the scan copy, my lord.
No.
Perhaps that's why CD was not.
One order was passed by the.
Or earlier, my lord.
This bench most probably had not passed the order. So that for that order, we are calling for. Order is an initial order, most probably. It is on 21/11. 21/11. So wherein in para third, para number 3, it is stated that the learned counsel for the petitioners will provide a PDF copy of this pre-arrest bail application to Mr. B. Sharma, learned additional PP, so as to enable him to transmit the same to the officer in charge of North Lakhimpur Police Station, so as to enable the police station to ascertain as to whether the petitioner is the accused named in the FIR dated so and so, North Lakhimpur PS case number, list consideration of bail. So that is the report.
Right.
Basically, one report was most probably called for.
A report was called for, my lord.
So that's why I have today I have dictated that the report may be
My
called.
lord.
And if you need the scan copy, then
My lord,
scan
in my
copy of the TCR
my-
along with the case diary may be called for. Otherwise-
Order.
Otherwise, there is
Lordship
nothing.
order on 21/11.
21/11/2020.
21/11/2010. That was the first initial order whereby the report was
Mine.
called. And you were asked to the prepare an PDF to send it to officer in charge
Mine.
of the station, not looking for
Mine.
report for as the up to date case diary no.
Not no.
Etu hobo enaka likho. Eta line khali add koro. As the case has already been charged at late, the scanned copy of the TCR along with the case diary be called for and the report from the concerned police station. You send the order.
Mine.
Further,
Mine.
your additional PP is hereby also directed to send the copy of order dated 21/11/2025 to the concerned police station to do the needful.
Mine.
Interim may be continued, Lordship.
Interim be continued till next day.
By order dated 24/11/2025, Lordship, directed to not to take coercive action, Lordship.
And that will be continued.
Yes, Lordship.
We are listing it on 24/3,
Mine.
23rd of April.
Mine.
All right, Lordship.
May it please your lordship.
You
Here,
have received here.
My lord, report was called for, my lord. My lord,
is the reason.
no case.
No case. That's the point. Hard MST Som, the learned counsel for the petition, also had Mr. B. Sharma, the learned additional PP appearing on behalf of state respondent. Report received from the concerned police station. Report received from the Persistent police station. Stating that till that there is no case has been registered against one Munna Ali, the petitioner of this case till date. In view of this, the present bail application is accordingly disposed of with a direction to the disposed of and the interim order granted on 18/2/2026 hereby stands vacated. However, the petitioner is at liberty to approach the appropriate forum in the event of registering any case against him.
I'm obliged.
Give the copy of the report along with
Mine.
the case. Yes.
My lord, 25, I have received the CD just now, my lord, after some time.
You are appealing for the informant.
Respondent.
Pardon? Pardon? Informant. Mr.
After
Ahmed,
some-
he
one second,
needs some time for
After some.
three, 4, and 5 are connected. Na?
Connected matters. Connected matters, Lordship, arising out of a matter which is pending in Amingao. And Lordship, here, these similar orders are passed in all the three cases before your Lordship, which is under challenge here. Now, Lordship, it comes to item number 3.
Item
This-
number 3.
Yes, item number 3. Now here, Lordship, this matter, Lordship, we have challenged an impugn order dated 26/2023 passed in a CR case number 202C 2017. Lordship. Now, Lordship, the order which is under challenge is at running page 57 at annexure 7, Lordship.
the lordship comes to the order of the trial court below. This is the order.
Yes.
And so far, before I come to the order, lordship, I would like to state that lordship, here the accused person is a educational trust, lordship. Now, this educational trust has been represented by its secretary, who is representing the said trust and lordship. And on the factual part, lordship, the trust was looking for some suitable plot of land, lordship, for building its school as per the CBSC norms for the purpose of his affiliation. Now, lordship, while he purchased 4 bighas and 3 kathas land, it was from 3 patadars, 3 co-sharers for a land which is situated at Mas Jalubari, lordship. Now, while the said land was sold to the trust, I being the accused person in the case before the trial court, the sale consideration was at rupees 1 crore 15 lakhs, lordship. And accordingly, while striking the agreement, lordship, 35 lakhs was paid to the complainants together, because there were 3 brothers, and the remaining balance consideration of 80 lakhs, for which some post-dated checks were being issued to the said brothers, the co-sharers, lordship. Now, lordship, here it was their specific case, lordship. It was their specific case which they projected, is that if lordship comes to the page number 4 in my pleadings part at para number 3, lordship. Para number 3, in short, page 4 of the petition. Page number 4 of the petition in the pleadings part, lordship.
Yes.
In page number 4 at the pleadings part, this is the case which was projected. I will make it short, lordship. Now here, he and his 2 brothers, Sri Hari Das and Alil Chandra Das, they purchased the plot of land. And if lordship turns to page number 5, they stated that out of the total consideration amount of rupees 1 crore 15 lakhs, part payment of 35 lakhs was made to the respondent and rupees 80 lakhs was paid to the revisioner, to the petitioner, by the petitioner by way of issuing some post-dated checks dated 9/2/2016. Para number 4, lordship, it is the check which was dishonored, lordship. And lordship, in my case, lordship, while the amount of rupees 1 crore 15 lakhs was the amount of the purported sale consideration, and 1 crore 15 lakhs, lordship, my case was that I paid in excess. I paid in excess of rupees 1 crore 15 lakhs by way of some cash paid in installments to all the 3 brothers who joined the sale transaction. Now, in this case, the complainant, lordship, while he issued me while he filed the case, I appeared. And lordship, in the course of cross-examination, lordship, it was also elicited if lordship comes, I have also annexed the cross of
No,
the
this is basically a case of NI under NI.
NI. And
Now-
the impugned
Now
order,
you have paid, you have submitted that you have paid the excess.
I have paid in excess. This is my case. This is my case that I have paid in
Through
excess.
checks and or what? Through checks also.
Through checks, somewhere with through checks, cash. But the thing is that, lordship, since there are co-sharers in the land, the payment was paid in full together, not in chunks, lordship. Because not in installment, 3 co-sharers were there. Combinedly, the payment was made, arising out from the transaction, lordship. Now, lordship, here,
No, what is the mode of your, payment?
payment were made through, some were made through by way of cash also, lordship. Some were made through checks. Since some post-dated checks were being issued, lordship, they failed to deliver me the possession of the land. As that point only, lordship, I stopped the payment. But my case, which I projected, is that I paid in excess. I paid in excess of rupees 1 crore 15 lakhs, which is the debt amount, which was the outstanding amount, lordship, in respect of the sale transaction, lordship.
No,
This was
on one hand, you are saying that you paid excess.
Yes.
Then what the post-dated checks were there?
But when I issued the post-dated checks, lordship, my case is that the checks were misused, lordship, because I already paid the amount in excess. So while they filed the case of dishonor before the trial court below, lordship, now while the cross-examination was conducted, lordship, I filed a petition under section 311 because 3 brothers were there together, 3 co-sharers. 2 brothers filed the case, but another brother, he was not made any witness in the case. I filed the petition for calling him as a witness under section 311. And impugning that rejection, dismissal of the petition, lordship, I am before this honorable. Lordship, if comes to this, to my petition, lordship, it is at page 50, annexion number 5. I've stated the reasons for why if lordship comes to page number
This
50.
is your application.
Yes, this is my application. This is my application at page number 51, lordship. Since the matter was posted at in the stage of argument, lordship, I filed the petition. Before commencement of the argument, lordship, I filed the petition. While hearing was conducted, the trial court had opined that this petition is not tenable, lordship, because it was reasoned by the trial court, lordship, that it was only to fill up the lacuna in the defense case, lordship. This was the primary opinion which was drawn by the trial court while dismissing the petition, as well as, lordship, the case of alleged liability towards the accused, since his other brother had filed the case, since he is not in the case, therefore, if it is, even if it is presumed that one of the brothers took the amount, how would it lead that there is no enforceable debt against the said complainant? This was the case. This was the reason while the said petition was rejected. Now, my lordship, now the purpose of section 311, lordship, if you might be allowed to read it out, the section, lordship, 311. 311, power to summon material witness or examine person present. Any court may, at any stage of an inquiry, trial, or other proceeding under this code, summon any person and witness or examine any person in attendance, though not summoned as a witness, or recall, re-examine any person already examined, and the court shall summon and examine to recall and re-examine any such person if his evidence appears to be essential to the just decision of the case. Now, our specific plea is here, lordship. The evidence of the said person, which we had invoked the section 311 to call him as witness, is very much essential for the decision of the case. And on the one hand, lordship, section 311, lordship, is one of the many provisions under the code, lordship, which strengthens the arms of the court to elicit the truth behind it. Because it is their averment which they have made in the complaint petition, lordship, that they have, together with the brothers, they have sold the land. And the transaction, since this is a transaction arising out of a land sale, all the three brothers had received the amount. I paid in excess, so there is no question of enforceable debt. And until and unless, lordship, the other brother is called as a witness in the case, it will not be possible for us to prove our case, lordship, that there is no outstanding debt in respect of the said case, though alleged by the complainant, lordship. And lordship, here, lordship, apart from the ground which I have taken earlier, is the ground that it is the section 311, for the purpose of extracting the truth, lordship, it is the cardinal rule in the law of evidence, lordship, the best available evidence should be before the honorable for the purpose of determining the case. These grounds I have taken in my pleadings, lordship. In my petition, it is being in the grounds portion I have reflected, lordship. So this is my case.
Just tell us the checks which are is the disputed check or the check in our question were issued in whose favor?
Now, lordship, some post-dated checks were given as a whole
favor?
to the complainant, to the sellers, lordship, the landowners, lordship.
All three brothers?
Yes, all three brothers, yes.
Names were there? Or
names were there, lordship. And
no, where is the check you have annexed here? Copy of the check?
Copy of the check, lordship. The complaint petition I have annexed, lordship. Here the copy of the check is here. Horidas, lordship, in the name of Horidas. Now, when check were issued to him, apart from that, lordship, major part of transaction were made in cash also during the course of transaction. They received cash also, lordship. But to misuse it, lordship, they filed the case. For the purpose of that only, lordship,
So what was the check amount?
check amount, lordship, is 10 lakhs. And in
10
the other two cases, some other amount, 10 lakhs are there, lordship. Total, check, I think. In 40, in this case, lordship, 202, the amount is 10 lakhs.
No, we are taking only item number 3 now.
Yes, yes. Item number
All
2,
the
10 lakhs.
cases are, my lord, arising out of the same sale deed, my lord. Same sale deed, my lord. Few of the brothers are, my lord, Patadars, my lord. They have jointly sold the land to the accused person, my lord. And the checks were issued in the same transaction, my lord. Separate checks were issued in installments, my lord. Some amounts to 10 lakhs, some amounts to 5 lakhs, some amounts to 10 lakhs, my lord. Among those checks, my lord, 3 checks were dishonored, my lord. As such, we have filed a case before the learned trial court.
Now, lordship, while the said case was filed, it is not that the leaving behind the person whom we proposed to call him before the trial court, he also, that said particular person also received huge amount of money, because it is their specific plea on their part that 3 brothers together, they joined the sale transaction. Therefore, the money is also come in joint, lordship. So while he received a major part of the money, lordship, for that purpose only, that there is no legal debt, legally enforceable debt, outstanding debt, lordship, for that particular purpose only, lordship, we sought to call the person as witness in the case, lordship. This is my specific case, lordship. And lordship, it is also opined in the order of the trial court, lordship, that the defense side could not state, if lordship comes to page number 59, lordship. Page number 59 of the order. In this order, lordship, in the first paragraph, lordship, the learned counsel for the complainant also submitted that in the instant case, the defendant's defense side could not state any reason as to why Mr. Anil Das was not previously summoned as a witness. It is only to fill up a lacuna in the defense case that this petition has been filed. Learned counsel for the complainant prayed to reject the petition. This was the case. Now, lordship, in inability to explain, lordship, a person why he was not called as a witness does not operate in an absolute bar, lordship. Because, lordship, every best avenue should be availed by the person, lordship, who is alleged of such any offense, lordship. Now, it deems fit, lordship, for calling such person for the purpose of the truth, because if he is not allowed, lordship, then there will be a failure, lordship, on our part to prove our case, lordship. This is my humble submission, lordship.
May I please, Lord? Lordship, undoubtedly under section 311 CRBC, my lord, the trial court can exercise power recalling of witness at any time. For additional witness, also section 311 can be used, my lord, at any time of the proceeding, my lord. There is no doubt about that power under section 311, my lord. Admitted fact. Further, my lord, those power when to be exercised? Not to fill up the lacuna, my lord. That is, Supreme Court has in numerous cases has stated that, my lord. But I will not go to that length, my lord. My lord, may kindly come to page number 1 of the petition, my lord. Page number 1, my lord.
At 50.
Of the petition, my lord. Present petition, my lord.
From the present petition.
Yes, my lord. Your Lordship has got it, page number 1.
Yes.
In the cause title, my lord, may I read it, my lord?
Hmm.
A criminal revision petition preferred under section 397, read with section 401 of CRPC, my lord. My lord, may kindly come to section 397, subsection 2, my lord. There is a clear bar under section 397, subsection 2 for issuance of exercising revisional power under section 397 in case of interlocutory orders, my lord. And my lord, this is a purely interlocutory order, my lord. So this petition itself is not maintainable, my lord. And this issue regarding bar under section 397, subsection 2, my lord, came way back in the year 1977. In the past, it was discussed in the case of Amarnath case, my lord. Then subsequently, other cases also discussed. Modulumia's case also discussed the ratio laid down by the Honorable Supreme Court in the Amarnath case, my lord. And thereafter, my lord, a full bench in the case of Girish Kumar Suneja, my lord, versus Central Bureau of Investigation has discussed what are the interlocutory orders, what are the intermediate orders. There are two things, man. Interlocutory orders are those orders which does not affect outcome of the case, my lord. Intermediate orders are those, my lord, if passed otherwise, my lord, may affect the outcome. Suppose discharge petition, my lord. I have filed a discharge petition, my lord. If court discharge me, then case will automatically come to an end, my lord. That order is an intermediate order. And in fact, my lord, section 311 petition for recalling of the witness, my lord, cannot be termed as intermediate. It is purely an interlocutory orders, my lord. Central Girish Kumar. May I submit a copy of the judgment authority laid down by the Honorable Supreme Court, my lord. My lord, may kindly come to paragraph 21, my lord. The judgment, my lord. Page 380, my lord. 830, my lord. Page 830, paragraph 21, my lord. May I read it, my lord? The concept of an intermediate order was further elucidated in the case of Madhulumia versus State of Maharashtra by contradistinguishing the final order and an interlocutory order. The decision lays down the principle that an intermediate order is one which is interlocutory in nature, but when reversed, it has the effect of terminating the proceeding and thereby resulting in a final order. To such intermediate orders immediately come to mind: an order taking cognizance of an offense and summoning an accused, and an order for framing of charges. Prima facie, these orders are interlocutory in orders, but when an order taking cognizance or summoning an accused is reversed, it has the effect of terminating the proceeding and terminating the proceeding against the person, resulting in a final order in his or her favor. Similarly, an order for framing of charge is reversed, has the effect of discharging the accused person and resulting in a final order in his or her favor. Therefore, an intermediate order is the one which, if passed in a certain way, the proceeding will terminate. My lord, in my case, my lord, how this order is intermediate order or interlocutory, that is clearly not an intermediate order, my lord. It is clearly an interlocutory order, my lord. And in case of interlocutory orders, my lord, section 300 and my lord, subsection 2 of 397 clearly lays down a bar, my lord. Further, my lord, This aspect has been discussed again in the case of Seturaman versus Rajama, reported in 2009, 5 SCC 153, my lord. Relevant paragraph is paragraph 5. my lord. Here, my lord, at paragraph 5, my lord,
Yes.
may I read it paragraph? Secondly, what was not realized was that the orders passed by the trial court refusing to call document and rejecting application under section 300 and 311 CRPC were interlocutory orders, and as such revision against this or those orders were clearly barred by section 397 subsection 2 of CRPC. Further, my lord, these two judgments again relied upon by the Honorable Calcutta High Court, my lord. In the case of Mahima Management Service Private Limited versus Creative Properties Developers Private Limited, my lord. While relying upon the ratio laid down by these two judgments, my lord, the Honorable Calcutta High Court has refused to exercise power under section 397, yes, my lord. 397, my lord. Subsection 2. Relevant discussion is at page 8, my lord, paragraph 20. May I read paragraph 20, my lord? Peruse the materials on record, also peruse the impugn order passed by the learned magistrate. I have also perused the application filed by the present petitioner before the learned magistrate under section 311 CRPC, along with the connected bank statement sought to be introduced, filed in the present petition of complainant. The case of the complainant is initiated under section 138, read with section 141 of NI Act, alleging the commission of offense by the present on the ground that on the ground stated therein. The learned magistrate has taken cognizance of the offense and proceeded to hear the matter. The list of witnesses and the list of documents had already been filed before the learned magistrate at the time of filing of the complaint case. The trial court has already been the trial has already been initiated. The examination in chief of the PW1 has been concluded. Now the dates are fixed for cross-examination of PW1. At this stage, the petitioner intends to introduce some more documents. The learned magistrate is of the view that the prayer of the petitioner in the application under section 311 CRPC contains a prayer of introduction of the computerized bank statement and other documents. The other documents were not specifically explained by the present petitioner before the learned magistrate. However, it is only the purpose of the petitioner to substantiate the fact that how the loan amount was received by the opposite party through their bankers. However, from the entire merits of the case, if does not appears that any point of time the opposite party have ever been disputed about the delivery of the check. Moreover, it is true that an order of rejection and application under section 311 is a truly interlocutory order according to the provision of section 397 subsection 2 CRPC of a criminal revision is not maintainable against such interlocutory orders. This is the law, my lord. This petition itself is not maintainable.
Okay, we'll come to the maintainability and rest part. What do you want to submit? Rest part, what do you want to submit?
Rest part, my lord, kindly come to the impugn order, my lord. It itself has stated the reason for rejecting the order, my lord. Page 61, my lord. Page 61 of the impugn order, my lord. May I read it, page second paragraph, my lord? May I read it, my lord? On perusal of the case record, it is seen that PW1 was examined and discharged on 20/03/2021. The accused was examined under section 313 CRPC on 69/2021.
Sure.
And he filed a petition bearing petition number 916 praying for allowing him to adduce evidence of DWs. Again on 19/2/2022, the accused filed petition number 350 submitted before the court that he would not adduce any defense evidence, and as a result, this case was fixed for argument. Subsequently, on 8/4/2022, the accused filed the instant petition praying for summoning Mr. Alin Das as witness in the case, my lord. My lord, at first, he has filed a petition that he will adduce evidence. Thereafter, he has voluntarily stated that he will not adduce any evidence. And in fact, my lord, if your lordship kindly comes to the petition filed before the learned court below, my lord, and starts from page 50 of the present petition, my lord. Nowhere in his petition, my lord, he has discussed why at this stage now he wants to adduce evidence of Anil Das. Why he has voluntarily withdrawn his right to adduce evidence. This is my humble submission. As such, I humbly pray before this honorable court to reject this petition, my lord.
Now, Lordship, I may be allowed to counter the submission made by the learned counsel regarding the point of interlocutory order, Lordship. Now, interlocutory order, Lordship, in one sense, are those order, Lordship, which are temporary in nature, Lordship. It doesn't decide the main dispute of the case. Now, under the code, Lordship, the interlocutory order, it is nowhere defined, Lordship. Nowhere it is defined. What is the meaning of interlocutory order within the criminal law, Lordship? This is my first submission. Second submission is, Lordship, that this order, Lordship, is not a temporary order because, Lordship, while we propose to call him as a witness, Lordship, in the petition, so far as the grounds we have stated, Lordship, the said person also receive a huge amount of money. So, Lordship, his evidence is necessary. In 311 itself, Lordship, it is clearly mentioned, Lordship, in the last part, Lordship, in 311, and the court shall summon and examine or recall or re-examine any such person if his evidence appear to be essential to the just decision of the case, Lordship. Now the dispute.
No, we are not done. Just you reply. You have already submitted that his evidence will be necessary, and for that reason only you file the petition under 311.
311, Lordship. And
now, as he was also one of the brothers who received money.
Yes. And
now, your date now, Mr. At the other counsel for the other side submitting on that it is a purely an interlocutory order, cannot be considered as an intermediate one. In that regard, do you want to submit?
Yes. On that regard only, Lordship, I have already stated, Lordship, that interlocutory order.
In that context, he cited 2-3 judgment of the Honorable Supreme Court also, wherein it is clearly held that 311 petition under 311 is purely an interlocutory. It cannot be considered even as an intermediate. In that regard, do you want to submit anything? That's
now, Lordship, it cannot be treated, Lordship. This is
your submission. Do you have any case laws or any
I have on this point, Lordship? At this moment, I don't have any case law. But to the point of 311, Lordship, for the purpose of calling the witness, I would like to give some case, rely on some case.
311 is already there. We don't disagree with this. 311 is there. If it is required for the just decision of this, even court can so moto also pass the order.
Yes, sir.
No issue and all.
No issue.
Now, but the question is that he raised the issue that your petition under 397(2), which is revisional, is not maintainable as is said purely an interlocutory, not an intermediate.
Yes.
In that aspect, do you want to submit? Otherwise, it is. There are many instances, there are many evidences, or there are many cases wherein it is held that if it is required for the just decision of this case, at any stage of the case, even the 311 can be allowed. No bar. Now, my number two is that he is one of the brother
Right.
who received the money along with the other two. Now, 3 checks were issued by you in dealing for the transaction. Though you have submitted that you have made some cash transaction, there are rather you have made excess payment to that. That may be, I won't disagree. Now the question is that, but however, the 3 checks are in existence, which were issued by you, signatures are there. Now, by calling this witness, do you think that this purpose of this, the issuance of checks and your signatures, etc., will be any help? Money is all right. Money is your submission is already that you have already paid some excess amount.
Since
These are the 2-3 questions. If you want to clarify it by today, or if you need some time.
we will need some time, Lordship, on the point of intermediary order or interlocutory order.
Interlocutory. Now,
Yes, yes, this is a pertinent
because
point which they have
it
raised.
depends that prima facie it seems that it's an interlocutory, but otherwise it may be an intermediate also, because by rejecting that order and all, it may affect the rights of the parties or the
Yes.
decision of the party.
Yes,
So in that case, that interlocutory may be accepted as an intermediate
yes, yes,
in many instances.
yes.
That's why I'm asking, do you have any relation to that?
On that point, Lordship, I seek some time, so Lordship. To
But we cannot keep it as a part head. Part head will, because next 2-3 weeks I may not be here also.
at two, Lordship.
There are matters.
Lordship, on that part, I need some time, Lordship, or
If you need some time, then it cannot be remain as a part head. That's what I'm saying. Simply,
because
part
Lordship,
head will be again create some problem.
because Lordship here, in one sense, Lordship is very right that 311 in prima facie appears to be an interlocutory one. But if it is not being allowed, Lordship, then it would hamper the just decision of the case, Lordship. So in that nature also, if it is seen, it appears to be intermediary in nature also.
So you have to place some authority in that regard, because they have placed some 2-3 judgments of the Supreme Court also, where exclusively it is held that 311 is purely
interlocutory.
So in that regard, do you have anything?
But if
Part
that
head, I
also,
can remain it as a part head, but part head will again create problem.
for that, Lordship, I need to rely on some judgment, Lordship, if I'm able to find out, Lordship, to satisfy my submissions, Lordship, that it appears to be an intermediary also, because the point of just decision is also being linked with the say provision, Lordship. It is not that if it would have been in a petition seeking just for the purpose of my submission only, Lordship. If I would have preferred any petition for seeking interim compensation, Lordship, that is something temporary, Lordship. Now, interlocutory order, Lordship, it itself signifies that it is a temporary order in nature, Lordship. But here, while I'm being disallowed, Lordship, it will affect the just decision of the case, Lordship. So therefore, I submit that a amount of discretion.
How it is a just decision of the case? Because
Because
three
if
checks
he
are
said,
there.
yeah, 3 checks are
Undisputedly, there are 3 checks in questions,
Three
maybe
checking.
post-dated, maybe whatever, but signatures, your signatures there, and those were, submitted or issued during that period of transaction where you have some legally debt was there.
Yes, yes.
So to comply with this, you have issued those checks, admitted. But yes, as per your submission, you have paid already excess amount, some in by cash also.
Some in by cash
So
also.
you don't have put any this money receipts, etc. You don't have anything.
It was, Lordship,
How?
during the course of cross-examination only, Lordship. We produced those, Lordship, and it was exhibited, Lordship. In the
Those money receipts.
yes, because in the
Okay. Yes, what
regarding in the cross-examination part also, Lordship, the trial court record, Lordship. 'Cause
My
it's-
lord, regarding that part,
the dictation bit and you do it
Lordship,
in that case, we keep it as a part head.
yes, in exhibit part, Lordship, that I have already submitted earlier, that some if Lordship put me a question regarding those money receipts, it is exhibited, Lordship. If Lordship comes to
We
these,
can go to detail of the merit of the case. I'm simply asking why it is necessary for you. That's why.
it is necessary because, Lordship, substantial amount of money has been received by his brother out of the sale consideration, Lordship. And out in
By his
respect of
brother means
those,
this that the witness whom you want to.
he is one
for.
of the brothers.
The other brothers not received.
Other brothers, Lordship, they are the one of the brothers, Lordship, he filed the case, one case, another brother filed two cases against me. This is before, and these all three.
No, the person to whom you want to call him as a witness, he is what? He has not filed any case.
He had not filed any case because major part of the money has been received out of the sale consideration amount. And admittedly, Lordship, those three persons, three brothers, together took part in the sale consideration, and the money itself, Lordship, is not paid into in individual, Lordship. It is paid as a whole, Lordship. This is my submission, Lordship. And since he had received the major part of the money, Lordship, his witness is necessary, Lordship, to establish my case, Lordship. Since I have paid in excess, Lordship.
3, 4, 5. Part. Now before Bihu, I don't have any. If I put it part, before Bihu, I don't have any.
So
It will
after
be of
Bihu, any
leading
date.
to Bihu only. Listing it as a part heard on 23rd of April at 2 p.m. Will be all right?
Lordship, 23rd of April, Lordship. 23rd of April, Lordship, I will be out of station, Lordship, for some matter at Silchar, Lordship. So,
The
but
hearing
because
date
that day I will
requires
be returning back on 23.
23rd only.
Yes, yes. Any date after 23, Lordship. On 27, Lordship. On 27.
27 is a Monday.
On 28, Lordship. Tuesday.
At best can be.
Yes, yes.
It's you're all right for you also.
My lord, part heard, my lord, next hearing on the issue of maintainability, my lord.
Oh yes, I have already heard to
Yes.
some extent. His submission is already there. Yes, it can be. fixed
I
at
may
court.
be allowed to reply to his submission, my lord, if he.
I don't know.
No, obviously not
That
today.
this
On
is
that day only. You can
on that day. Yes.
change. Matter is partner. Listing matter on 28th of April at 2 p.m. To hear on the point of maintainability. No, hearing it. Part here. 28th April at 2. We're listing it on 28th April at 2 p.m.
Yes.
Just submit on this. No.
On that point only, because other parts are already before.
Yes, yes,
it is on
already
record,
there.
Lordship.
Yes, it is
On
on
that point only, Lordship.
We have received what we have received, case diary or scan copy?
Case diary.
Case diary.
On last occasion, your lordship wanted to see whether he appeared or not on this respect, your lordship.
Okay.
He's in phone number 18, Lordship, and he will be there. Right?
Monday.
Yes.
Oh, now he has already arrived. Yes, come on.
Senior, these are appearing in this case, my lord. He is on leg, my lord.
Who is appearing?
D Das, my lord.
D Das is
My
appearing.
lord. Last day, my lord, he is appearing, my lord. In this case, my lord.
Mr. Ahmed has some issues. No, oh, two, there are many matters. Not
We will wait for some time. If not come, then your lordship may fix. 10-15 minutes. So.
Is he arguing it?
Oh, yes, yes, okay. Not
Problem.
Number 8 and 9.
May it please, your
Yes.
lordship, I am appearing on behalf of the respondent in item number 8, lordship. Lordship, I need some time to file a reply, lordship, because the petitioner has goes outside for treatment. For
No,
therefore,
you're for the petitioner or for the respondent?
respondent, lordship.
And who is appearing on 9? You are appearing. In item number 9. These are all connected matter.
Yes, ma'am.
In case against the DB case.
No, whatever, connected matter.
Yes, Lordship. One maintenance against maintenance, one against DV.
DV.
Yes.
But
Much
for
similar.
the same petitioner or respondent.
Yes. Can be.
Yes, then what? We have. Are you are not going to file any?
On last occasion, they also take time for filing reply. Order.
Okay. So what had happened? On the last occasion also you have taken time.
No,
as
lordship,
submitted
last
by-
occasion, they could not provide the copy for which
Immediately, we had
on the very same
reply.
day, they have supplied this, thus, respondent is outside, so for which how is it possible for me? And the signature is required for submit the reply, lordship. Minimum 1 week's time may be given, lordship, if possible.
Interim order passed earlier, maybe only.
Interim was there.
18.
Item number 8.
8.
Hard MS dust.
Also, reply.
Your good name?
D. Burman, lordship.
D. Borman. And D. Borman. Is submitted by Mr. Borman that he needs some more time to file a written reply. And he could not prepare the reply as the respondent is staying outside. In considering the submission made by Mr. Borman, let the matter be listed. Yes, but he needs 1 week or 2 week time.
1 week is possible.
The prior Bihu, there are many matters. So it will be immediately after Bihu, that is on 20 April. Will do? 20 April.
No, if possible, take it on 21. Then
21.
21.
21 করে দিব 21 April, enabling the respondent file the written. Or 8 to দিব hard MS
M dice.
You are appearing in 8 also, no?
Yes.
Hard MS M that's the learned counsel for the petition. Also hard Mr.
Yes, I am. Lordship,
Yes.
there is an interim order in item number 9.
Just a second.
8 in also 8.
8 to interim be continued. Interim be continued till instead of listing. In item number
8 to
9, you are for the respondent. You are Mr.
Mr. Katai.
You are Mr. S.I. Ahmed. Your name is not here? Koon hole? Oh, also heard Mr. S.I. Ahmed, the learned counsel for the petition. Is the matter on 21/04/2026. Along with criminal division petition number 349 of the
There is an interim order.
interim be continued till next.
Obliger.
Deeply obliged, lordship.
Please, your lordship.
State is here only.
My lord, here instruction was sought for my lord regarding service of notice, my lord. But today also we have unable to receive any information, my lord. But as per their, my lord, the victim girl has married to the another person, and the residential address is also different. For that purpose, it is difficult for us also, my lord, to find
Can
out.
you provide us the present address of the respondent number 2?
No, Lordship, we don't have.
No, as you have submitted that she got married with another person,
That,
so
that new address is not known to us.
My lord, that's how we will.
Lordship, it is not.
her parents' house is where?
Parents don't.
We are sending notice in her parental address?
No, my lord, the earlier address, my lord, whatever.
That was her parental address, Lordship.
Parental address?
Lordship. Lordship, for on 24/10, Lordship, instruction was supposed to take. After that, 10/2/2026, instruction was supposed to take on last date also, Lordship. And it is not a POXO case, Lordship. Respondent number 2's attendance may not be necessary, and if necessary, Lordship may appoint an amicus curiae.
What nature of case this is?
Lordship,
What nature of case?
69 is there, section 69, Lordship.
Promise to.
Lordship may, at this stage, appoint an amicus curiae. From last 1 year, Lordship, I am waiting, and stay is also not there. My prayer will be considered after respondent number 2's present, Lordship. So today, Lordship may appoint an
Okay, then we
amicus.
can appoint.
Lordship.
But the petitioner has failed to give any new address, my lord. That's why perhaps it is not. Notice was not served.
Yes, they
Amicus
submitted
curiae may
that
appoint.
they are also not in a position to say the new address because. But as per your information, she got married with another person.
And they have filed one additional affidavit also.
Affidavit, Lordship, I have annexed some photographs of.
Photograph is okay. You are Mr. R. Hussain?
J.S. Ahmed.
J.S. Ahmed. Heard Mr. J.S. Ahmed, the learned counsel. Also heard Mr. B. Sharma, the learned additional PP, appearing on. Next part is submitted by Mr. Sharma that though he tried to make contact with the IO, he could not take any instruction in regards to service of notice on respondent number 2. Mr. Sharma further submitted that as per the information of the petitioner, the respondent number 2 already got married with a person and her new address is also not provided to the respondent, state respondent. Mr. Ahmed, the learned counsel for the petitioner, submitted that the new address is not known to them and the case is pending since more than 1 year, and for which, and due to absence of the respondent number 2, the case could not be proceeded. Next part, considering the entire circumstances of this case, this court is of opinion that one amicus may be appointed to represent the respondent number 2. Accordingly, Mr. N. Mahajan is hereby appointed as an amicus to represent the respondent number 2. The registry will do the need in providing relevant copies etc. to the appointed amicus. List the matter, yes.
Lordship, next date of appearance is 9/4, Lordship. Before that, any date, Lordship.
9 is holiday, 10 is holiday, 8 we are listing.
9
is election.
9 is election, Lordship. That day is.
Oh yes, 9 is election.
That day is fixed for appearance, Lordship, in the court of.
Obviously, that
Earlier
will be
it will
another
go
day.
to the after 2 months.
9 is obviously immediately after vacation.
Mine.
2020.
Lordship.
A scan copy also received, mine. Trial for the
Scan copy of the
Fixed for hearing, Lordship.
20.
20 for hearing, Lordship.
No, for admission hearing it will come.
Admission hearing.
Lordship.
20 April for admission.
Obliged.
This 12, their private respondents are there, Mr. Paul. Oh, yes. What is this case about? Is it case of washing?
Yes, your lordship. Watching of charge sheet, your lordship, and the order dated 11/6/2025, your lordship.
Yes.
Your lordship, the accused petitioner states that the FIR lodged by respondent number 2, your lordship, alleging that his mother, respondent number 3, who is a 65 years old retired teacher, was befriended by the petitioner via social media, your lordship. Your lordship, who thereafter allegedly took advantage of her and sexually assaulted her and extorted money from her, your lordship. Annexer is that FIR is at page number. Type copy of FIR is at page number 16, your lordship.
16.
Yes. Your lordship, my humble submission is that the allegation in the FIR, your lordship, subsequently the statement under section 161 of CRPC was inherently improbable, self-contradictory, and unsupported by independent evidence, your lordship.
It's a contradictory statement.
Yes, your lordship. An
Statement of the informant or what? Respond number 2. Statement of the respond number 2 informant is
your lordship.
contradictory.
Yes, your lordship. The statement which has been under 161 statement, your lordship. The FIR which was filed in Sabwa, your lordship, and then it had been transferred to your lordship, Goshala in Maligaon, your lordship.
Initially lodged at Sabwa.
Sabwa, your lordship. Your lordship, in this case, no prima facie case has been made out under section 376 subsection 1 of IPC against the petitioner, your lordship. And in as much as there is no materials for showing physical force, your lordship, coercion or lack of consent to constitute rape, your lordship, under section 376 subsection 1 of IPC, your lordship, lodging the instant FIR. Your lordship, the victim's own statement reveals that her interaction with the petitioner began voluntarily, your lordship, through social media, and that she willingly shared her personal information and invited him to her residence, your lordship. And the allegations of sexual assault introduced belated, showing clear throughout and malified intention, your lordship. There is no medical evidence, your lordship, no forensic materials to sustain the serious charges of section 376, your lordship. Page number 9, page number, your lordship, from page number 6, we have enamored the grounds, your lordship. And in the accused petitioner has falsely implicated in this case, your lordship, on page number 10, your lordship, and narratively contained in the FIR as well as the subsequent statement of the alleged victim, and the complainant is highly improbable, inconsistent, and self-contradictory, your lordship. Lordship, for that, the allegations of extortion and blackmailing are unsupported, your lordship, by any consent, evidence, and claim of transfer of money lacks evidence, your lordship. As it has been said that there is a transfer of money, your lordship, there is no evidence, your lordship. For that, the investigation has been conducted on one-sided manner without proper verification, your lordship. And there is no any electronic evidence, chat records, or other digital communications that would exonerate the accused petitioner, your lordship. or that the present criminal case is attended with malified intention, instituted only to wreak vengeance upon the accused petitioner and to coercion him under social pressure, Your Lordship. The FIR that has been filed is under social pressure, Your Lordship. So this FIR has been filed after a year, Your Lordship. On the day of Bihu, Your Lordship, I think on 2023 or 2024, Your Lordship. 2024, I think, Your Lordship. 2024 Bihu, when the grandson came to know out of the chat records, Your Lordship. The same is liable to be quashed, Your Lordship. The in the continuation of criminal proceeding would cause irreplaceable harm and injury to the petitioner, Your Lordship. That the petitioner has no filed any other similar. This is my humble submission.
Okay, any other submission?
Yes, yes.
Yes, sure.
My lord, here, informant also appeared before the court, my lord. Here from the, I have gone to the record, my lord, TCR, my lord. And from the statement under section 164, my lord, she has categorically implicated the accused petitioner, my lord. Here, what happened is, here in the ballot, some parties said that she was raped. Thereafter, some video was also viral and demanded money for that 10 lakhs rupees was demanded. That is also there in the 164 statement, my lord. And in the 161 statement also, my lord, he was consistent, my lord. And after getting sufficient material, my lord, I also submitted charge sheet, my lord, against the present petitioner, my lord. And now the perhaps it is in the appearance also, no? Still, it's the way. It's 2025. My lord, victim is yet to be examined, and my lord, considering all matters, it is not a case to
What is the state of the case at present?
my lord.
Case is at the stage
My-
of evidence.
Evidence
Charge is already framed or not yet?
charge framed on my lord, 11 June 2025, my lord. Under section 417, 376 1, subsection 1, and 384, my lord. Extortion, my lord. All the sections are there, my lord. 1 3. My lord, no PW is examined till today, my lord. And someone issued to the informant and victim. That is there, my lord. But no PW examined till today, my lord. Next date was fixed for 16/3, my lord. And they have took time on the pretext of my lord, the application is pending before the court, before the lordship, my lord. That is on 15/12, my lord.
Yes, Mr. Pardon? Some developments mean?
Lordship, as per, from the part of the respondent lordship, they have no objection in this.
No objection.
Lordship.
Acha.
Leave it to lordship.
Part 164 statement, I have taken my lord.
Yes, I'll do it. Part, you are Mr.
A.M. Siddiqui, your lordship.
Part Mr. A.M. Siddiqui, direct counsel for the petition. Also heard Mr. P. Sharma, the learned additional PP, appearing on behalf of state respondent. And Mr. P. Bordeaux, the appearing on behalf of respondent number 2 and 3. Informant. Informant victim of this case. This is an application. The section 528 PNSS for quashing of the charge sheet and order of framing charge against the present accused petitioner against the petition. Next one. It is submitted by Mr. Siddiqui that the FIR has been lodged with some false and concocted allegations, and without verification of the facts and without any proper investigation of this case, the IO has filed charge sheet against the present petitioner by charge sheet number 65 of 2024, dated 29/09/2024, and the case has already been, and the case is also taken cognizance by the learned additional session judge FTC Dibrugarh. No, then Dibrugarh, then why you're saying this Maligaon?
One of the cases we filed, the FIR was, and Malika also, the truth.
But it is.
Yeah, it's a
case is
Dibrugarh,
pending before
case.
Dibrugarh only.
Yes, your lord. Place of occurrence.
Case is also, the charge has also been framed against the present accused petitioner under section 376(1), 384 by 417 IPC. IPC post. Mr. Siddiqui, but next one, Mr. Siddiqui further submitted that there is that the statement made in the statement made in the FIR and the statement made by the respondent number, she is respondent number 3 or 2?
She was
Three.
the victim 3.
No. She is victim
She's
is
three.
respondent number
3, your lord.
And the statement made by the respondent number 3 in her 161 CRPC statement, and no, about first time statement made in the FIR and the statement made by the respondent number 2 under section 161 CRPC is contradictory, and she also did an inconsistent statement has been made by her in her statement recorded under section 164 CRPC. There is from the materials in the FIR itself, it is seen that there is no prima facie case is established against the present petitioner to frame charge against him under section 376(1) IPC, nor there is any evidence of monetary transactions, etc., to frame charge against him under section 384 IPC. From the statement, it is seen that she herself invited a accused petitioner to her residence, and thereafter, if any sexual contact was there, it was purely a consensual one, and there was no force applied to her by the accused petitioner. To the order he submitted, there is no medical evidence, and the medical evidence to support the case of the prosecution. That apart, the statement made by the petitioner, statement made by the respondent number 3, and the statement made in the FIR is highly improbable and and that cannot be considered that there was any prima facie materials to proceed a case against the present petition. Mr. Siddiqui further submitted that there is no digital evidence also to prove the transfer of money, and only with a malafide intention to harass the petitioner, the FIR has been instituted with some false and concocted allegations. In this accordingly he submitted, this is a fixed case wherein the petition can be the entire criminal proceeding, including the FIR and charge sheet, can be quashed by invoking the power under section 528 CRPC. If the case is if the case is allowed to proceed further, it will cause prejudice to the petitioner and also hamper his reputation in the society. Mr. Siddiqui accordingly submitted that the petition may be the entire criminal proceeding pending before the Court of Learned Additional Session Judge Dibugor may be set aside and quashed. Next paragraph. Mr. Sharma, the Learned Additional PP, submitted in this regard that there are sufficient prima facie materials to proceed with the case further. He further submitted that the statement made by the respondent number 3 in 161 CRPC and 164 CRPC are found to be consistent, and there is clear allegations of rape against her. Clear allegations of rape against the present accused petitioner. He further submitted that the charge, considering the prima facie material, the charge accordingly framed under section 417, 376, subsection 1, 384 IPC against the present petition. However, till date, no witnesses is examined by the prosecution, including the victim. No witness prosecution. He accordingly raised objection and submitted that this is not at all a fit case. Quashed the entire proceeding by invoking the inherent power under section 528 BNSS. Next one. Mr. Bordole, the Learned Counsel, appearing for the respondent number 2 and 3, that is the informant and the victim of this case, however, submitted that he has no objection if the criminal proceeding is quashed against the present petition. Next para, hearing this submission to the hearing this submission made by learned counsel for both sides. I have also paid the case record and the case record, comma, annexures file along with the petition, as well as the scanned copy of the TCF which has been received by the court. From the contents of the FIR as well as from the statement by the made by the victim under section 164 CRPC, it reveals that there is sufficient incriminating materials brought against the present petitioner, and further the prima facie the statement of the FIR also prima facie establishes a cognizable offense against the accused petitioner. It cannot be held that there is no material or no material in the statement made in the FIR as well as the statement made by the victim under section 164 CRPC to held that to held that the case is lost only with the bona fide intention to what some officer did. Bona fide intent only to harass the presentation. Rather, the prima facie there is sufficient material to establish case against the present petitioner. Next part. The Honorable Apex Court in case of Vajanlal, Pakname Afran Vajanlal so and so in para so and so has held that it of the Rupamar Palu Paiba, Rupamar Pailo, so and so Kovidiba. Next para. In the present case, it is seen that there is such material to held that only for the malafide intention to harass the present petitioner, the FIR was launched or instituted by the son of the victim. Rather, it is seen that there is a privacy materials against the accused petitioner, and hence this court is of opinion that this is not at all of the case to set aside or quash the entire criminal proceeding pending before the learned additional session judge FTC Dibrugarh at the state by invoking the power under section 528 CRPC. In view of this, the present petition stands dismissed. Your petition stands dismissed.
Right. My lord, here up-to-date CD and my lord, report was called for my lord. Today we have not received my lord.
So Lordship, just only one thing. My Lord, your Lordship may peruse the order dated page 16, where my account was freezed and other things were also taken, they were taken by the investigation officer. My only question before Malada is this: they have to look into whether from seizing to freezing, whether the investigation officer has given the information to the magistrate from the date of after seizing and before freezing, whether that information was given to the magistrate.
That's why CD is required.
102 and now 106.
Freezing and defreezing, this of prayer for freezing and defreezing, whether information was there, that is the crucial.
My lord. That's why CD is required. My lord.
Because before the court, there has to be some information.
Up-to-date CD. AB mentioned
AB is different. No.
Then probability, have you got any information or information from?
Not received. Up-to-date CD and report not received. My lord.
But now the question is this: though the investigation may be going on, but his account has been freezed.
Right.
So that has to be when it can be fixed. And I don't think prior this election will be proper. Probably may not.
That's why my lord, part city also not available. Like they are busy in election law and all.
Because next week or this there are 3 more days, most probably 6, 7, 8 are working day, 9 and 10 are holiday. But prior
Reopening
election may not be possible.
Reopening.
No,
Exactly on reopening.
Reopening while
21st, my lord.
21st.
Yes, 20 or 21st can
My
be
lord,
given.
21st man.
Mr. P.K. Roy Chaudhary, Dilanet petitions, both 13 and 14 apply. So far, Mr. P. Shah, Dilanet petition PP applying. It is submitted by Mr. Sharma that CD along with the report which was called for is not yet received by the prosecution. In that context, Mr. Roy Chaudhary submitted that the accounts of the petitioner has already been freezed and defreezing is required as defreezing freezed during the investigation of this case, and for which the matter is also urgent. Considering the submission made by Mr. Roy Chaudhary, the IO is hereby directed to furnish the case diary along with the report before the next date of listing without any. List the matter accordingly on
21. 21st.
21st. We are listing it.
Right.
Let us see, and you also take some initiative, but accounts has already been freezed.
Right.
Matter is seems to be urgent.
Both 13 and 14, man. Both.
Yes, both 13 and 14. It was 25. Yes, Mr. Ahmed, we are still waiting. I have seen sitting still there. The informant side is still not. You are from whom? Achha, just a second.
In my case, that counsel is not, for the informant is not here.
Not here, that's why.
Not here.
Is Sharma, what to do? Oh, yes, he is here. He is still there. Ahmed, and two may not be possible.
Yes. In two also I have some.
You have some subject. We have received the case diary after the city. When it can be? Monday to many matters are there, I think.
Tomorrow?
Monday may not be 31st. We can retain the case diary till then. Will be okay, Mr.
Okay.
Due to some waiting for the respondent, the matter is actually. However, Mr. Sharma, the learned additional PP submitted in this report. Let's see, the updated case diary has already been received. In view of this, let the matter be listed on 31st, 31, to ensure case diary be retained till next 31.
Interim order, okay.
Okay, interim be continued till next day.
Problem.
25. 31, yes. So you are for the amicus. Petitioner full. Appellant? Mr. T. Deody, R.S. Deody, they are not present. One eye is also there. Oh,
The matter may be passed for time being used.
31.
Yes, sir. Really sorry.
One eye is there. No?
Yes.
Oh, okay.
Obliged, Lord.
Yes, you are for the petitioner?
Yes, sir.
Yes, who is the Mr. Botak? It's a case of 2012.
Yes, sir. Lordship, here the incident is pertains to the year 2005, Your Lordship.
2005.
Date of incident is 16/10/2005, Your Lordship. What happened, Your Lordship?
It is, what is it? It is a revision.
It's a revision.
Appellate court upheld by the conviction under section 92.
Partly allowed. Partly allowed. Sentence of 2 years was set aside and only the fine was imposed by the appellate court. We are against the fine. Your
Case is under which section?
Under Factories Act, Your Lordship.
Oh,
The
Factories.
conviction was under section 92 of the
92 Factories Act.
Factories
Factories
Act.
Act 21. Yes, what is this?
Lordship, a brief summary, Your Lordship.
Yes, sir.
Lordship, this incident pertains to a worker who was working in a tea factory, Your Lordship, in Jalan Nagar South Tea Estate. Your Lordship. What happened, Your Lordship? He was assigned a duty where he was to feed certain leaves into the machine for crushing. And at one point, Your Lordship, accident occurred, Your Lordship, and his head got crashed and he died on spot, Your Lordship. So that is the incident, Your Lordship. That was
Head got.
Lordship.
Which hand or head?
Head, Your Lordship.
Oh my God.
Subsequently, his wife was also compassionately appointed, and compensation worth rupees 1,36,000 approximately was also awarded to their family, Your Lordship, including funeral expenses. Lordship, the incident is of 16/10/2025. Lordship, thereafter.
2005. Not
Sorry,
25,
2005, Your Lordship. 16/10/2005.
16/10/2005.
Yes, Your Lordship. The incident was reported on the same day to the police. Thereafter, it was reported to the factories, the chief inspector of factories, and under his instruction, an inspector he visited the place of occurrence only on 18/10, Your Lordship. 18/10/2005. 2 days later to the incident, he had visited, and then he had prepared a report, which was placed before the CJM, Your Lordship. That was registered as a complaint. Complaint is at page 14, Your Lordship. Basically, he says there are certain violations, and
Complaint is at page?
at page 14, Your Lordship, Annexure A. Before that, Your Lordship, the petitioners presently or the accused persons are one Ashok Prasad Saraf, who is the managing director of the Ethelwood Company, Your Lordship, who owns that particular one of those gardens was the Jalan South Tea Estate, Your Lordship. They have many gardens, and one of those was the Jalan South Tea Estate at Dibrugarh. And the petitioner number 2, Ashok Sood, he was the then manager appointed in the factory, Your Lordship. Complaint, Your Lordship will find at page 14, Your Lordship. Lordship will find at the same page, Your Lordship, down below, breach of Rule 3.1 prescribed under Section 1 of Section 6 as the management, that is the occupier and manager, did not obtain previous permission from the Chief Inspector of Factories in respect of the installation of machinery, rotor vane, first bank, etc. Lordship, the Factories Act, under the Factories Act, Section 19(2) is the penal provision for the entire Act, Your Lordship. All the convictions and punishments are generally taken from there, Your Lordship. And certain other violations are also mentioned. Number 2, there is subsection 1 of Section 3 on the next page, Your Lordship. 33 of the management did not provide them and maintain any guard, cover, or secured fencing over the opening in the wooden platform over the rotor vane machine. Then number 3, Section 32A of the management failed to provide sound construction and proper maintenance
or small size wooden platform, etc. Your Lordship. Basically, the sections are Rule 3.1 under subsection 1 of section 3. Rule 3.1 probably they are referring to is that the Assam rule, Your Lordship.
Three one.
3.1, that is Assam rules, Your Lordship. The main provision is under section 6 of the Factories Act, Your Lordship. First, Your Lordship may peruse, or Lordship will proceed one by one, Your Lordship. Will proceed the complaint. No, first. Section 6 of the Factories Act, Your Lordship, if Your Lordship takes up.
Yes.
Lordship, approval, licensing, and registration of factories, Your Lordship. That is very important, factories. Your Lordship. The state government may make rules, subsection A, requiring for the purposes of this act the submission of plans of any class or description of factories to the chief inspector or the state government. AA, subclause AA, requiring the previous permission in writing of the or the chief inspector to be obtained for the site on which the factory is to be situated and for the construction or extension of any factory or class or description of factories. Requiring for the purposes of considering applications for such permissions the submissions of plans and specifications. Prescribing the nature of such plans and specifications by whom they shall be certified. Requiring the registration and licensing of factories or any class or description of factories, and prescribing the fees payable for such registration and licensing and for the renewal of license. Requiring that no license shall be granted or renewed unless the notice specified in section 7 has to be given. Subsection 2, if on an application of for permission referred in clause so and so of subsection 1 accompanied by plans and specifications required by the rules made under clause B of the subsection sent to the government or chief inspector by registered post, no order is communicated to the applicant within 3 months from the date on which it is so evident the permission applied for in the said application shall be deemed to have been granted, Your Lordship. Lordship may not go further into the section, Your Lordship. Basically, what I would like to impress upon Your Lordship is that the entire section deals with the registration, licensing, etc. of the factories. It is nobody's case that the factory itself did not have the permission. Lordship, that is obtained and it is renewed from time to time. Yes. Lordship, it is only with respect to a particular machinery that was the reason for which the incident had occurred or accident had occurred, Your Lordship. And if Your Lordship proceeds to the Assam rules, Your Lordship, again to...
Okay, then we'll let.
Hello, for your Lordship, right, yes. I have a prayer in item number 37. Only thing is that I am otherwise stuck up in court number 18(2). your lordship kindly accommodates me for the time being. In case I fail, because my colleague will be here. If your lordship accommodates the time being, I will come back and.
No, definitely it will be after 2 only now. Well, this matter I'm just hearing.
That's why,
So-
because at 2, I am stuck at a hearing in court number 8. So if the item reaches only for the time being, I am just making an advance prayer.
Time being, now see, the question is that if it reaches only, otherwise we are not hearing the item number 33. The 34, 35 are also there.
Okay.
Then only your 37 come.
Yes.
Whether it will reach or not at this stage, I cannot say.
Okay.
If it reaches, then definitely we'll accommodate. And if it doesn't reach, then
Then it's
it's okay.
Derived by the learned trial court on his own, your lordship. That was never the case, your lordship. At para 15, your lordship, I'm continuing to read, your lordship. In our case, it is stated that the platform over the rotor vane machine guarded with fencing in its 3 sides, and one side was kept open through which green leaves were pushed to the mouth of the rotor vane machine. According to PW1, the mouth of the rotor vane machine was not guarded. Lordship, the guarding is on the 3 sides, and one side it was left open for them to put the leaves. Lordship, and that has been categorically stated by PW1 in his evidence, your lordship. Thereafter, your lordship will proceed to so far the safety measures in the same paragraph, your lordship. So far the safety measures taken in their rotor vane machine is concerned, their evidence is silent. Accused Shri Ashok Sood gave his evidence as DW1 in his evidence. It should have been DW2. In his evidence, he has stated that there was a wooden platform in front of the machine, but in the evidence, he never stated about the presence of guarding of fencing in the front of the mouth of the rotor vane machine to prevent any untoward incident. Lordship, guarding was there on the 3 sides, and that was sufficiently guarded, and mouth was left open for them to facilitate for putting in the leaves. Therefore, at the time of incident, the mouth of the rotor vane machine was open and no safety measures were taken by the manager or occupier of the said company. Now, your lordship, the PW2 has, in his evidence, he has stated that he neither has the knowledge or he was accompanied by any medical expert, your lordship. And these findings have been arrived at based solely on that report, which was prepared by the PW2, your lordship. And all the evidences that was quoted in that report, your lordship, all hearsay, your lordship. PW2 in his evidence did not prove that an application for approval was submitted in the Chief Inspector of Factories on 15/7/2005. In his evidence, he simply stated that when Exhibit Kha was shown to him, Exhibit Kha is an application for approval dated 15/7/2005. That is recorded, your lord. Therefore, the machine was working without any approval from the Inspector of Factories, Assam, and the layout of the said machine was delivered to the office of the Chief Inspector of Factories, Assam, after the occurrence of the incident. We are not so much concerned, that is important, Lordship. We are not so much concerned about the approval of the rotor vane machine because an approval cannot shift burden to others. Lordship, what is required is that first of all, the factory should have registration, license, etc. Thereafter, if any new machinery is inducted, your lordship, under provisions of Assam rule 3A, they are supposed to take new approvals. Here, your lordship, the learned court below proceeds to find that we are not so much concerned about the approval of the rotor vane machine because an approval itself cannot shift the burden to others, your lordship. The approval was subsequently granted. That is an admitted position. Lordship, if there was any failure or a lack of provisions of safety, etc., that could have been rejected, your lordship. But that is not the case. The approval was subsequently granted.
That means what you obtain the approval subsequent to the incident only.
Lordship, our application
But
for
then,
approval.
but during that time also the workers were working.
Lordship,
Workers were working there.
Yes, your lordship.
even without the approval of the thing, for installation of the machine. Then why?
Lordship, it is a admitted position that approval or application for approval was applied much earlier to the date of incident, and thereafter it was pending for approval. Lordship, the sections I would take your lordship to the sections, your lordship, which says within a period of 2 months, if the same is not approved, it is deemed approval, your lordship. However, in this case, at a belated stage also, the approval was granted with the same outline, same plan, same particulars of the machine. Had the rotor vane machine been fitted with strong guard fencing, no such incident would have occurred. Hence, the accused persons, namely Kishori Prasad Saraf, Executive Director, and Sri Ashok Sood, Manager, Jalan Tea Estate, Jalan Nagar, South Tea Estate, cannot be escaped from the liabilities of the punishment of so and so and so. Lordship, here learned court below has come to his own finding, your lordship, without any evidences or expert opinions, as admitted is the position in our present case, your lordship. Considering the facts and circumstances of the case, I do not find any ground to extend the benefit of provision of section 360 CRPC to the accused persons. I am of the view that the accused persons do not deserve any leniency. Therefore, each of the accused person is sentenced to suffer simple imprisonment for 2 years and compensation of rupees 50,000. The compensation after realization be given to the wife and the dependents of the late Hiram Lohar. Thereafter, your lordship, the accused persons or the petitioners had appealed, your lordship, and the lordship will find the judgment of the appellate court at page 30. Regarding facts, your lordship, will come to para 31. Only one paragraph I would like to rely on. Paragraph 3, your lordship. Firstly, that is only part with the appeal. On being agreed with the aforesaid judgment and order passed by the learned CGM Dibrugarh, accused appellants has filed this appeal on the grounds that the judgment and order of conviction are bad in law. CGM failed to appreciate the fact of the case and the defense of the accused appellants properly, and also failed to appreciate law and read the evidence properly. The statements of 4 eyewitnesses recorded by the complainant during his inspection were also proved the innocence of the appellants accused. The investigation report do not corroborate the facts stated by the eyewitnesses. There were only 2 eyewitnesses, your lord, PW1 and PW4. Rest were all hearsay. Learned CGM illegally convicted the accused number 1, terming him as the occupier of the Jalan Nagar tea estate factory without any evidence on record. He is neither the occupier nor the owner within the meaning of section 93 of the Factories Act. Hence, the conviction of accused number 1 is illegal and not tenable in law. The complaint case was manufactured and not at all reliable. The conviction is bad in law since the same is without jurisdiction and is in violation of statutory directions under section 92 of the Factories Act. It is stated that while the wife and the dependents were already received the sum of rupees 1,39,614 under the provisions of Workmen's Compensation Act, which is reflected in the judgment of the learned CJM, the compensation cannot be imposed on the accused for payment of the same to the wife and the dependents of the deceased, and nor the dependents are entitled to any such compensation. The learned CGM did not take cognizance of the fact that one of the dependents of the deceased was already employed in the tea estate. As such, the judgment is illegal. These were the grounds that were taken up, Your Lordship, in the appeal. Now, Your Lordship will find at page 32, Your Lordship, para 5. After turning to the present case from the evidences of the PWs, Your Lordship, what? Para 5, page 30, para 5, Your Lordship.
5?
Para 5. At page 32, Your Lordship.
Oh, yes.
After turning to the present case from the evidences.
Yes.
After turning to the present case from the evidence of the PWs and the investigation report of factory inspector complainant, it is revealed that there was wooden floor chang with three sides fencing and one side was open for lifting tea leaves to the floor below. The rotor vane machine was under the wooden floor. It is revealed that the wooden floor was 6 feet length, 6 feet breadth, and its height was 6 feet, 6.5 feet. It is also revealed that there was a 2 feet by 2 feet square hole on the floor under which the mouth of the rotor vane machine was installed. Accused manager during his evidence as DW2 admitted the fact that the factory inspector investigated the site in his presence, but the accused appellants had challenged the liability of the accident and the learned advocate for the appellant submitted that the accused had provided proper guard to the hole for protection of the workers, and prosecution witnesses also supported these facts. Lordship will come down, your lordship. 1, 2, 3, 4. On the thereafter four lines thereafter, your lordship. I find that PW1 and PW3 are the eyewitnesses and they are workers of the tea factory.
I have gone to, or I find.
I find that PW1 and 3.
How many lines later?
Lordship, fourth line, your lordship. After the.
I have gone through. Or
I find that.
One sentence is I have gone through the evidence on record.
Lordship has page 33, your lordship.
Yes, 33.
33.
Anyway, you read. Go on.
Yes, your lordship. I find that the PW1 and 3 are the eyewitnesses and they are the workers of the factory. They, during their evidence, describe the wooden floor and shows the existence of fencing on three sides of the wooden floor only, but did not say about the fencing of the whole of the floor. Now, this is it. Both the courts have given their own findings, your lordship, whether the mouth should have a fencing or not, your lordship, whether it was properly installed or not. All these evidences were never, lordship, corroborated or the medical expert opinion was never recorded, your lordship. And where PW2, who is the inspector, he himself admitted that he does not have the technical know-how, your lordship. So that is one of the findings that both the learned courts have given, your lordship. Whole of the floor. PW2, the complainant himself has proved his investigation report during evidence. Seen that PW4, also an eyewitness, he after the alleged accident had pulled out the disease from the mouth of the machine through, though DWs in their evidences asserts that they took all the precautionary measures by providing guard and fencing, but they could not show the deceased worker fell down inside the rotor vane machine and crashed his head as described by the accused manager in his accident report in form number 18. The appellant accused number 2 as DW has failed to disclose the cause of falling of the deceased on Hooper the rotor vane machine. On the other hand, from the evidences of PWs and exhibited photographs, it is proved that there was no fencing and safety guard on the whole of the wooden floor. So I find that the accused being occupier and manager of the said factory failed to take proper precaution measure as provided by the Act. Lordship, whatever evidences were led by DWs, Lordship, they were also subsequent. Lordship, they were not popular evidence, your Lordship. They were not present at the time of incident. They could not have stated for what might have been the reason, you know. And then there is also a finding that the accused being the occupier and manager of the said factory to take. I find that accused being the occupier and manager of the said factory failed to take proper precautionary measure as provided by the Act. Lordship, again, this is another finding.
No, finding in a sense, yes, obviously they are occupier
Yes,
and the
Lordship,
manager of the said factory.
under the Factories Act, Section 2N provides for occupier. Now, that is very important, your lordship. It does not say about the owner. Although Section 93 deals with the owner and manager, however, the majority of the sections under Factories Act
is supposed to be dealt with while proceeding with the meaning of occupier. Occupier is a person, he might not be the owner, but should be having the entire management and the liabilities while maintaining the entire premises. Basically, he is in full control of the entire premises, is the person who is the occupier. Lordship will find in section 2N, your lord. For a moment, Lordship has the act, your lord. Section 2N, occupier of a factory means the person who has the ultimate control over the affairs of the factory, your lord. Provided that in the case of a firm or other associations of individuals, any one of the individual partners or members thereof shall be deemed to be the occupier. In the case of a company, any one of the directors shall be deemed to be the occupier. Your lordship, firstly, the section proceeds with having the ultimate control, your lord. Only if that person is not there, then all these provisos will come into effect, your lord. And in the absence or in cases of a company, only then one of the directors shall be deemed to be the occupier. Now this entire factory was assigned to the petitioner number 2, who is the manager, your lord. And petitioner number 1, he is the managing director of the company Ethel World Private Limited, your lord. And that particular company is owning one of the tea gardens is the Jalan South Tea Estate, your lord. Lordship, if I may proceed with the judgment, your lordship, of the appellate court, first appellate court. At para 7, your lordship, page 34.
Yes.
Turning to the present case, I find that present accused appellants were the manager and occupier of the Jalan Nagar South Tea Factory itself, in term of section 2N of the Act. That is not true, your lordship. Probably the manager could have been the occupier, maybe considered as an occupier. However, it is our submission that petitioner number 1 can not be termed as an occupier in view of his capacity as a managing director of the Ethel Wood company. They were not assigned by some other company to do the job job in the Jalan Nagar South Tea Factory. So I find that the reliance placed by the learned advocates for accused appellants is not applicable in this case. So in view of the aforesaid discussion and reasons thereof, I find that the accused persons are the occupier and manager of the Jalan Nagar South Tea Estate Factory, and they are liable for the accident of the deceased Tukiram Lohar. I find that the appellants were rightly convicted by the court below, and there is nothing to interfere in the finding of the learned court below. Lordship, thereafter at para 9, at page 35, your lordship. After going through the facts and circumstances of the case, I am of the view conviction of sentence with fine will meet the ends of justice instead of sentence of imprisonment for the accused person. So the sentence of simple imprisonment for 2 years is hereby set aside. Each of the accused persons is directed to pay an amount of rupees 50,000 as fine amount. The fine amount, if realized, shall be delivered to the dependents of the deceased as compensation. So the appeal is partly allowed with direction to pay the fine of rupees 50,000 each to the accused appellant. What if I would like to rely on
Your Order of the appellate authority.
Yes, yes.
Where is the original case?
Lordship, I read through it, Your Lordship. At page
Oh, yes.
17.
Yes.
The finding or the order is contained as page 28, Your Lordship.
It starts from page 17.
Yes, Your Lordship. Trial court judgment is a long judgment, Your Lordship.
Hmm.
Lordship, down below, fifth line from the bottom, Your Lordship. I am of the view that the accused persons do not deserve any leniency. Therefore, each of the accused is sentenced to suffer simple imprisonment for 2 years, Your Lordship, and compensation of 50,000. That was the finding of the learned trial court. Lordship, I would like to rely on the judgment of this honorable court. Lordship, here also a death had occurred. However, there was a a brick cylindrical portion of brick which was under repair, and there was some incident and the person died. Your Lordship. I would like to rely on para 5, 6, and 7, Your Lordship. If I may read you. Para 5. Admittedly, the sole prosecution witness PW1 was not present when the incident took place. As per his own statement, he visited the site subsequently, and on the basis of the statement made by the workers and other witnesses, he submitted the offense report. Same is the case as ours. Surprisingly enough, none of these persons or witnesses were cross-examined by the prosecution during trial, and when the lacuna was brought to the notice, the same was brushed aside without any finding. Admittedly, PW1's evidence is hearsay evidence, as he learned the incident from other witnesses, and it is not admissible in evidence in criminal trial. Para 6. The trial court has acted on the evidence of PW1, wherein it was stated that the rope used for lifting the portion of the chimney was not of required standard, or it was not of standard specification, etc. Admittedly, none of these articles were examined by the expert, and there is no report of the experts to show that the said accessories tools used for the purpose of lifting the chimney were not present as per specifications required under Section 29 of the Factories Act. Further, the complainant did not produce these articles before the court to show that they were not in conformity with the required specification. The mere statement of the complainant that he found the rope, etc., to be of not required standard or quality cannot form basis for conviction, as he arrived at the place of occurrence subsequently. It seems that the complainant was in hurry in taking up the matter in discharge of his duties as required under the Act. We may refer to the provisions of Section 91 of the Factories Act, which provides that an inspector may at any time take samples and get the things examined or analyzed by any government analyst. Admittedly, PW1 did not perform his duties as required. Para 7. In this case, we find that there is another aspect of the matter which was given complete go by both the trial court as well as the appellate court. As per the prosecution story itself, the said chimney was dismantled for the purpose of repairing, which means that the chimney was lifted and brought to the ground for the purpose of repairing. It seems so during the process of dismantling. Further, we find from the PW1's own evidence that one portion of the chimney was successfully installed, and the accident took place when the second part of the chimney was being placed. So, here the admitted position is that there were 3 guard walls in our case. Your Lord. 3 guard walls were there. Only
at the opening of the mouth, there was no guard wall, and that is where both the courts below Lordship proceeded to give their own findings, Your Lord. Whether it was properly guarded or not, that was not determined, Your Lordship, at any point of time. All these things go to show that the apparatus used for the purpose of lifting the chimney was of required strength, and we find force in the submission that the incident was because of an accident only, and where no negligence on the part of the management. There cannot be presumption of things that the rope used was not of required specification. The burden was on the prosecution, and admittedly the prosecution has failed to discharge the same. Lordship, I would like to rely on another judgment, Your Lordship, pertaining to the capacity as a director, Your Lordship, whether that can be considered, Your Lordship will come to para 9.1. Lordship, directly to page, last page, Your Lordship. No, Your Lordship, the prior page, Your Lordship, previous page. Lordship, down below, number 3. The only question which requires determination is whether any person, Your Lordship, has it. Second last page, Your Lordship, of the judgment is written as page 42. Second last page, Your Lordship, regarding finding on that issue, Your number 3, Your Lordship, down below. The only question. Second last page. Second last page.
Para 9.
Para 3, Your Lordship. That is one of the serial numbers, Your Lordship. Under para 9 only it is.
9, serial number 3.
Serial number 3.
The line starts with
The only question which requires determination. That will be second last page, Your Lordship.
very belly.
Follow the 3. Lordship has it.
Giving in such a manner, there is other answer also there.
Sorry.
Give a proper on the call.
Sorry.
Excited very good.
By mistake, the office copy was provided. The only question, Your Lordship, requires determination is whether any person other than the director of the company can be the occupier under section 2N of the Factories Act. And to that question, our answer is in affirmative. In our judgment, the inspector of factories was clearly in error, claiming that the amendment to section 2N of the Factories Act, no one except the director can be occupier. So the finding of the learned First Appellate Court as well as the trial court, Your Lordship, of convicting the petitioner number 1 is not correct, Your Lordship.
Lordship will proceed. The only question which authority is to examine whether the person nominated is one of who has the ultimate control over the affairs of the factory, and if it is so found, the inspector will register him as the occupier. This being the position of law as enunciated, the Karnataka and Bombay High Courts now enunciated by the Karnataka and Bombay High Courts. Now let us see whether this is good law as laid down by these two high courts. A bare reading of section 2N as amended will show that the material part of the section defining an occupier remains unaltered, and so a person who has ultimate control of the factory can be nominated as the occupier. And it also must be borne in mind that always a director may not be in ultimate control of the factory. It is ultimate control of the factory which is the touchstone and not the ultimate control of the company. A director may live at a distance. But we would not go into the later part here. The conviction was hypothetical. Now, Your Lordship, where I had stated that pending approval, Your Lordship, seemed to be. Lordship will find the Assam rules that I provided earlier, Your Lordship. Section Rule 3A.
Yes.
Lordship, there it says no site shall be used for the location of factory or building in a factory constructed, permission extended or taken into use as a factory unless previous permission in writing is obtained from the state government, etc. Lordship will proceed to the proviso, Your Lord, on the next page. Your Lord. So it says basically that all the plans, etc. of the plant, building, factory needs to be approved, Your Lord. Proviso one sixth line from provided that if the above authorities, Lordship, has it? If the above authorities neglect or omit for 2 months after the receipt of such an application to sanction or refuse it should have been refused permission, they shall be deemed to have sanctioned the proposed site for construction of a factory or construction of construction of a factory absolutely, and the chief inspector of factories may proceed with the consideration of a application forthwith. So within 2 months, if that is not acted upon, that is deemed approval. However, the chief inspector of factories may proceed therewith also. So that was our case, that the approval was granted subsequently on 24/10/2005, whereas our application was pending as on 15/7/2005. However, Lordship, the learned court below have proceeded that there was no approval as such. That is not at all the case. Approval was subsequent, but it was there. So, Lordship, in brief, Your Lordship, petitioner number 1 being the managing director of the Ethel World company, and who is owning one of the tea estates, and that is Jalan South Tea Estate, is one of their tea gardens, Your Lordship. Is not at all or cannot be convicted, Your Lordship. And number 2, Your Lordship, regarding the conviction of the manager, Your Lordship. Lordship, the entire evidences that were relied on, Your Lordship, regarding the specifications, etc.,
was solely from the report submitted by the inspector, your lordship, who admittedly did not have the technical know-how regarding the working or functioning or of the machinery, your lord. And case is that, your lordship, the mouth of the machine is guarded on the 3 sides, and one opening is left for the workers to put in the leaves, your lord. And throughout the entire proceedings, your lordship, it can at max be termed as an accident, your lord. That might occur, your lord. Therefore, I'm praying that the compensation part also be set aside.
Yes.
Your lordship, my lord, here my learned friend has argued the entire matter and has pointed out, my lord, every material evidence which were already, my lord, cited by him before the Royal Court, and during appellate stage also he argued all these regarding the, my lord, all those arguments were, my lord, advanced by him before the appellate court. And my lord, here this is criminal revision petition, and scope is very limited. So, my lord, at this stage, your lordship, whether, my lord, there is any error apparent on the face of the record, and whether, my lord, there is any, my lord, anything, my lord, apparent on the face of the record that trial court has totally not considered at all, my lord, any evidence, my lord, and whether this is a case of no evidence at all, my lord. And regarding the, my lord, in the present case, my lord, only your lordship, I would like to point out, first of all, my lord, although, my lord, regarding approval of a for installation of a particular machine, my lord, he has argued a lot regarding that. Prima facie, my lord, admitted, my lord, there is no approval for installation of the machine in the, my lord, factory. My lord. And in fact, my lord, regarding that aspect, my lord, trial court has also stated that even no application was also pending, my lord. Trial court had finding of the trial court, my lord. And therefore, my lord, while there is no such application pending and there is no approval for, my lord, installation of a particular machine in that factory, my lord, ultimately, my lord, during evidence, he cannot even, my lord, suppose if prior approval would have been there, my lord, that could have been, my lord, at the time of evidence, case would have been a different case, my lord. They can, my lord, by citing, my lord, evidence, they would have, my lord, placed that at that point of time, factory inspectors, my lord, get opportunity to, my lord, visit the site of the factory. They, in fact, visited that there is, my lord, appropriate safety measure is there, my lord, to, my lord, protect the, my lord, workmen, that there is no such any such incident occurred, my lord. Regarding that aspect, there is nothing. So prima facie, it seems that there is no, my lord, approval for installation of that machine. So regarding that aspect, so right now they even cannot say whether there was any safety, my lord, my lord, measures were taken by them or not, my lord. Regarding that aspect also, the factory inspector was not even get any opportunity prior to installation of the plan that whether there was any safety measures was there or not. Thereafter, my lord, ultimately one incident happened there, my lord. The main, my lord, fact is the trial court has also, in fact, my lord, while passing that judgment by the trial court, has stated regarding the installation of that machine and, my lord, whether there is any prior approval or not, that is, my lord, irrelevant. But at that point of time, although relevant, my lord, because, my lord, but at that point of time, one incident occurred, and during that incident, my lord, evidence, there are 4 witnesses, my lord, 4 witnesses, my lord. After taking, your lordship may kindly come to page 11 of the, although, my lord, of the judgment of the trial court, my lord. I just like to only point out the relevant portion, my lord. I am just pointing out the relevant portion.
11.
We are not so much concerned about the approval of the rotor van machine, because an approval cannot shift the burden to others. Therefore, had there been a valid approval, the result would be same. Had the rotor van machine been fitted with strong guard or fencing, no such incident would have occurred. Hence, the accused persons, namely Sri Kishori Prasad Saraf, Executive Director, and Sri Osuk Sood, Manager of Jalannagar South Tea Estate, cannot be escaped from the liabilities of punishment under Section 92 of the Factories Act 1948. Therefore, the accused persons are convicted under Section 92 of the Factories Act 1948. Considering the facts and circumstances, I do not find it. So, my lord, considering that aspect, all those, my lord, after considering all those evidences, my lord, evidences of the even, my lord, evidence of the my lord, DW2 is also vital. My lord, at that point of time, my lord, what he stated, my lord, that's because he has pointed out the evidences right now in this. Therefore, I am pointing out to your lordship, my lord. Yes, my lord. So far as the safety measures taken in their rotor van machine is page 11, my lord, last portion of the page.
Yes.
So far, the safety measures taken in their rotor van machine is concerned, their evidence is silent regarding the PW1 to 4. My lord. Accused Sri Osuk Sood gave his evidence as DW1. In his evidence, he has stated that there was an wooden platform in front of the machine, but in his evidence, he never stated about the presence of any guarding or fencing in front of the mouth of the rotor van machine to prevent any untoward incident. So this is the evidence of DW2. And thereafter, my lord, regarding the present other argument regarding these accused two persons are owner or occupier, my lord, of that factory or not, those things were already, my lord, discussed by the trial court. My lord, by the appellate court has also, my lord, discussed that if he is not the owner and occupier, who has appointed him in that, my lord, factory, my lord. Regarding whether he has, my lord, produced any evidence before the trial court, my lord, that I am not the occupier, and from the, my lord, who is the occupier, there is specific, my lord, section, my lord, of the Factories Act, my lord, specifically defines who are he is the, my lord, admittedly director of the company, and my lord, section of the Factories Act, my lord, specifically say while he is the director of the company, definitely, my lord, trial court and appellate court has also, my lord, considering all those aspects, that he is the occupier of that factory. Otherwise, who has appointed him? Whether anyone has appointed him as a, my lord, director of the company, my lord. If he is not the owner and occupier, my lord, whether he is appointed by anyone, my lord, or any company has appointed him to look after, my lord, as a, my lord, as a man, or as a occupier of that, my lord, factory, my lord. So all these aspects were already considered by the learned trial court, and even appellate court has also, my lord, considering all these evidences, my lord, has not already findings of the trial court, my lord, trial court or appellate court has upheld the findings of the trial court. However, my lord, trial court has modified the, my lord, sentence, my lord, otherwise only regarding the, my lord, appellate court order question. Difficulty is that very old pending methods. File is not in our, my lord, record. The last portion of the appellate court order, my lord. After going through the facts and circumstances of the case, I am of the view conviction of sentence with fine will meet the ends of justice. So, my lord, ultimately appellate court has modified, and only, my lord, fine, sentence of fine will meet the, so only that was upheld by the, my lord, appellate court. So, my lord, from the materials evidences on record, my lord. Otherwise, my lord, appellate court has, my lord, rightly, my lord, felt the conviction only the fine part. So at this stage, my lord, my prayer before you, this is not a case from the material evidences from the record, my lord, to interpret by way of this revision petition. Otherwise, there is no apparent error in the, my lord, that there is no such evidence, my lord. There is he also failed to show there is any, my lord, apparent error on the face of the error. There is any illegality in the, or, my lord, order of the trial court, order of the appellate court. He is only trying to find out that there are two findings of the trial court and appellate regarding that point, my lord. Otherwise, that is also, my lord, regarding the fact that whether those the accused persons were taken any safety measures while the incident occurred or not, my lord. Regarding that aspect, there are evidences, my lord. The trial court, those evidences specifically, my lord, pointed out. Even in fact, DW1, their evidence, my lord, stated that in fact there was no such fencing, my lord. There was no, my lord, guard was there, my lord, while the incident occurred, my lord, to protect the. This is it, my lord. This is like a platform, my lord. Platform, in between the platform, there is a hole, and from where, my lord, those, my lord, workmen, they will have to, my lord, spread those leaves there, and thereafter, in that platform, there was no such, my lord, space, or in everywhere there is only, my lord, tea leaves. And in between that, that incident occurred. While, my lord, those leaves were, my lord, he, my lord, spread to that, my lord, hole. At that point of time, he suddenly, my lord, fell down in that hole, and this incident occurred. So if there would have been any protection, definitely he would have not fell down there in that.
Mr. DW1 denied the suggestion that there was no guard wall, and rather he has stated that there was fencing over the mouth of the.
Cannot repeat the evidence.
Lordship, for a moment, your lordship, probably here.
Heard you not more than 1 hour 15 minutes.
Lordship, section rule 3A only deals with the additional machinery which needs approval if only the prime movers exceeds the horsepower already installed in the factory. There was no such evidences or findings, your lordship, to that aspect, your lordship. And
regarding, my lord, this is whether approval is there or not, those things are immaterial. But an accident occurred at that point of time, there was no protection there, no safety measures were there. Regarding that aspect, evidence is there.
Already, your lordship, the compensation was given voluntarily from the company side, including the wife of the deceased person was also employed. And your lordship, petitioner number 1 and 2. Petitioner number 1 is the managing director of the company, your lordship, at that point of time, and petitioner number 2, your lordship, is working, your lordship. I pray that the conviction be set aside, your lordship, view of their future difficulties that might be faced.
Appellate court has rightly made the upheld the only sentence. Finally.
Yes, it will be always.
Deeply obliged.
May it please, your lordship. In this case, I'm convicted and sentenced under section 10.
The IA.
IA, yeah. Since 13/10/2025, your lordship. 167 days I'm behind the bars, your lordship. In
Since
fact,
when you are behind the bar?
I am for Viswadas here.
No, you are behind the bar since when?
167 days, Your Lordship. 164 days. Section 10 of post-COVID, Your Lordship. The only argument that I want to make, Your Lordship,
Yes,
is that
you are appealing for? Yes. Yes.
the victim, Your Lordship, she has stated there are two parts, Your Lordship. One is the victim has stated that while she was inside the room, the accused person came and he tried to molest her, Your Lordship. And in the meantime, she started screaming, and her brother, the PW10, he came inside, beat the accused with a piece of stick, and then the accused ran away. That is the story of that is the statement of the victim. Your Lordship, the PW10, he categorically stated that the brother, he stated that he came inside, the accused had grabbed the girl, he was grabbing the girl and against a wall. He has pushed the girl against a wall. When he came inside, the accused went away. He didn't state anything about the fact that there was molestation or the accused was doing something. He merely said that the accused went away. So the learned special judge, Your Lordship, while convicting and sentencing me under Section 10, relied on the statement of the victim and convicted me, Your Lordship. That is my respectful submission, Your Lordship. At this stage, I'm not making an argument on merit, Your Lordship. On any stringent condition, Your Lordship, the sentence may kindly be suspended. I be allowed to go on bail, Your Lordship. On any stringent condition, Your Lordship.
Conviction was of how many years?
164 days.
Conviction is of?
The conviction is of 5 years, Your Lordship. I'm convicted under Section 448 and Section 10. Five years for Section 10 and 1 year for simple imprisonment for Section 448 here also. If Your Lordship may kindly peruse the statement of the victim in the judgment, Your Lordship, which I have annexed with the I at page 24, PW3, para 15.
Page 20.
Page 24, it starts, Your Lordship. Para 15, para 15.
Yes. Yes.
Your Lordship, may I read it? The victim stated that the informant is her mother. She knows the accused person, she Biswada. She calls him Biswada. She did not remember the date of the incident, but stated that, however, it occurred at about 2 p.m. At that time, her brother, J and M, was outside fetching water to the cow. The accused person is the truthfulness of the statement made by such a witness. What would be more relevant would be the consistency of the statement right from the starting point till the end, namely at the time when the witness makes the initial statement ultimately before the court. It should be natural and consistent with the case of the prosecution for the accused. There should not be any prevarication in the version of such a witness. The witness should be in a position to withstand a cross-examination of any length and howsoever strenuous it may be, and under those circumstances should be give more room any doubt as to the fact of the occurrence, the persons involved, as well as the sequence of it. Such a person should have correlation with each and every one of the other supporting material, such as the recoveries made, the weapons used, in the manner of offense committed, the scientific evidence, and the expert opinion. So, Your Lordship, I am on the part, the manner of the offense committed. According to her, Your Lordship, if we assuming for a moment, your lordship, not admitting the fact, assuming for a moment the accused came and he tried to do that immoral act with that particular victim who is an underage girl, your lordship. But the brother, according to the brother, he was very much there. So whatever was happening, when he went inside, when he was shouting, the brother ought to have seen the incident. But the brother has not stated the incident in such a manner. The brother has also refrained from stating that he was the person who carried the wood and he had beaten the accused. So there is an inconsistency in my respectful submission, Your Lordship. That ought to have been considered by the learned trial court. However, Your Lordship, the learned trial court had treated the PW3, the victim, as a witness of sterling quality and has convicted me. Your Lordship may kindly peruse the judgments. Paragraph 69 for a moment, Your Lordship. Page 59, I'm sorry. May I read, Your Lordship? In the instant case, paragraph 69, page 59. In the instant case, it is already seen that the accused person committed the offense of sexual assault as laid down under Section 10 of the POSCO Act. The victim testified that the accused person came to her house asking for pan tamul and dragged her and opened her pant halfway. PW9 also testified that the victim was inside the house, and when she raised the alarm, he reached inside the house and then he saw the accused person grabbing her beside the wall. Therefore, it is clear that the accused person committed the offense of sexual harassment inside the house of the victim. By grabbing her inside the house and then pulling down her pant, the accused person entered into the house building in the position of the victim, uses
without going into the merits of the matter, Miller. There is a direction of the Honorable Supreme Court that before maintenance is awarded, an affidavit of assets and liabilities have to be filed. It was not done in the present case. So one way of settling the matter can be, if the matter is remanded back to the trial court, directing filing of affidavit by both the parties, and thereafter making an assessment as to how, as to the quantum of maintenance. Probably that will balance the interest of both the parties. Otherwise, my lord, that is one aspect of it.
None of the parties had filed their affidavit.
No. So that is one aspect where your lordship can remand the matter, directing the trial court to take the affidavit from both the parties, and thereafter make an assessment of payment of maintenance. Then the wife's right will also remain protected. The husband's right will also remain protected, subject to assessment by the trial court. That is one aspect of the matter. But otherwise, on the merit, I have very limited prayer. There was also a DV case filed by the wife, and in that case,
sorry, I cannot hear the matter. I have some box now, so full matter hearing I cannot. Are you agree with the proposal of?
No, my lord. The submission which has been made by my learned senior friend, it perhaps, my lord, is not fully correct. There was both the disclosure of the DV as well as the affidavit.
No, I am not on the disclosure
of the DV is okay.
Affidavit has been filed, my lord.
Affidavit on assets and liabilities is
filed, my lord. It reflects in the order itself, my lord. The
No,
order
no, that
was filed.
That is perhaps not the affidavit in terms of the, what it ought to have been in terms of the direction in Rajneesh versus Neha. Yes.
Short date. My lord, may fix a very short date, my lord. As this, I am the wife, I have a
But
child.
now you're getting something, or you're not?
Yes.
No, my lord. I have the instruction, my lord. Although there is a payment of maintenance of rupees 6,000 for the child and 12,000 has been stayed for me by this honorable court in the instant proceeding. So I am not getting anything. Although he is duty bound to pay to the child, that payment is also irregular, my lord. So therefore, I am finding it very difficult to manage my day-to-day affairs. So there is an urgency, my lord, to dispose of the matter.
Your part is stayed.
My lord.
I mean, payment for the wife is stayed.
Payment for the wife is stayed. but the my lord, for the
Child is-
child, it has not been interfered with by this honorable court, my lord. But only thing is that though there is a no stay in the child part, my lord, but the payment is very irregular, my lord. We can demonstrate it from the records also. Now, my lord, distance warrant had also been issued, and while disposing of that matter, my lord, there is a condition had been, my lord, fixed by this honorable court that for the child, payment should be made regular, my lord. But till date, it has not been made regular in violation of this honorable court's order also. I am not on that, my lord.
No, it's okay.
But my lord,
I can understand. But
I am
now-
not
now
troubling my
my
lordship.
question is that
My
what Mr. Doctor is submitting,
Yes, yes, my lord.
that whether there is, he is submitting that his party, most probably, I don't know,
My
has
lord.
not submitted any affidavit.
No,
of
although,
SSL liability.
my lord, no,
But as far your client is concerned, or
My
your petitioner
lord.
is concerned, whether they have
Yes,
filed
yes,
already.
yes, my lord, because if we go by the order, my lord, at page 80, I am just reading a small paragraph, my lord.
your lordship
But
can start
as
from
the-
79.
My
No,
lord,
it's
my lord,
79, the last paragraph, it
In
it
the
is reflected.
affidavit of assets and liabilities, the second party is, my lord, may kindly turn to page 79, my lord. I am just reading a small part. In the affidavit of assets and liabilities, the second party stated that he requires rupees 5,000 as expenses for his son from his second wife. Again, a person having nominal income of rupees 400 with dependent parents hardly afford a second marriage. The second party apparently in his affidavit of assets and liabilities conceal the fact of his income by not producing the bank statement, etc., as required by law, an adverse presumption may be drawn against him. During hearing, it has been brought on record by the second party that the first party has been awarded maintenance of rupees 4,000 per month for herself and her minor child in proceeding under the DB Act. So, my lord, this court taken cognizance of the said award, but nothing prevents this court from awarding monthly maintenance to the first party and her minor child under the proceeding if the amount so awarded is not adequate. And considering the income of the second party as claimed and stated by the first party and her witnesses, the first party and her son entitled to much higher amount of maintenance.
Okay, that is the observation of the
That
court.
is the observation. So therefore, there was a assets and liabilities has been discussed, my lord. So, my lord, may I pray, my lord, perhaps some records are required, my lord. From the, if the learned trial court record is called for, my lord, everything will be transpired, my lord.
Now, what, subject to, my lord, what he has said, my lord, what I was on, at the beginning, I said that I am making a very neutral statement. This affidavit which the learned trial court has referred to, my lord, my understanding is that, my lord, this is not in accordance with the direction that the Honorable Supreme Court has passed. Supreme Court has passed a direction giving the particulars in practically the manner in which the affidavit declaration has to be made. These do not suffice that, do not satisfy the requirement of that. That's why, my lord, I said
No, but
that
if you go by the order as Mr. Mia has submitted, I mean read, so the order says that you suppress those things, your bank accounts and all that. Otherwise means
that's why, my lord, I say
liability is in the format.
no. That's why, my lord, I said that there is a format prescribed by the Honorable Supreme Court, and it has to be filed in that format.
No,
Now,
that format is most probably there because what I have read, I have heard, it is there that you have concealed about your
exactly
bank accounts, everything.
Exactly. That's
So
why, my lord, I said.
It is there, but you have not filled up.
Well,
those
that's
things.
why I said, my lord, that since it has not been done properly, let it go back. I'll file a fresh. I'll file a fresh
Yes, my lord,
affidavit.
somebody will, my lord, conceal. They will come to the High Court and then they will say, I will
No, no.
disclose.
I'm, my lord, at the very beginning, I said, my lord, I am not going into the merits of the
I am
matter.
not doubting my respected senior friend submission.
I am making a very neutral statement that this is one area where possibly a reconciliation can be made.
Record here. Isn't it? Record টা
Record কল করে নি।
আছে বোধহয় একটা কজ লিস্টে দেখাইছে নাকি কজ লিস্টে টিসিআর আছে
Scan copy we have received that.
My lord.
or otherwise your lordship can fix it on some other day, and so far as the DV Act is concerned, my lord, although it has been taken note of, but my contention is that
We have received the scan copy, one part we have received, but we have to go through whether this SSN liabilities part are here or not.
My lord.
and whether it is in conformity with the format that the Honorable Supreme Court has prescribed. That is the thing.
Okay then. Yes, Mr. Bhuya, when it can be, because
My lord, my lord, I am not troubling my lordship with this Fagan, my lord. On next week, any date, my lord, because we have urgency, my lord. The child is starving, my lord. I don't have any other income source, my lord.
Well, my instructions are that we are paying. Anyway, since he is raising a dispute that
no,
the
no.
payments are
not
not
saying
being
that
made.
you are not paying, but very irregular.
Mal. Fully not
That is his
irregular,
side.
irregular.
Then.
Any date, if your lordship so pleases, before Bihu, subject to what he will say, or after Bihu.
For Bihu, 6, 7, and there are many matters are there. 9, 10 onwards, there's a holiday.
There is a holiday.
10 is a holiday.
Or if it is fixed on some hearing day, my lord, then perhaps it will be easier. Otherwise,
My lord can hear and dispose it of on merit, my lord. And we will have to abide by, my lord.
Tuesday, Thursday. 21. 21 is a Tuesday. Can it be on 21?
My lord.
yes.
The
21st April.
21st of April. But by then you just take, some instructions from your client also in regards to submissions of SSL liabilities.
But
On
what
that day
I
you
find,
can
my lord,
submit.
from the order of the Honorable Trial Court, it is not in the manner prescribed by the Honorable Supreme Court.
By the time we have received this scan copy, you can go through also.
Yes, yes.
Scan copy and just submit. Hard
21st
Mr.
April.
S. Dr. the learned senior advocate assisted by Mr. S.H. Rahman, and also heard Mr. A.R. Flynn, the learned counsel appearing for the respondent number 2, and Mr. P. Waterford, the learned petition PP for the state. Due to positive, then the matter could not be heard. Let the matter be listed on 21/4/2026 for hearing. And both the parties are hereby also asked to proceed with the hearing on the next day.
My lord, deeply obliged.
Deeply obliged.
My lord, in the meantime, they will abide by the earlier court's order. My lord. At least the payment for child
Just
may.
ask your client.
My lord.
They are paying.
No.
Mr. Rahman, if you can balance, ask your
He is
client.
saying that they are paying.
My lord. No, my lord.
No, paying is
Now, whether regular or
not rejected.
That is the issue,
But
my lord.
most probably some interim be continued till next year.
My lord.
And just ask your client.
So far, my instruction last night also, Your Honor, 1 month or 2 months from the interim order, there may perhaps left.
Otherwise, he is paying.
He's a very rich man, my lord. Lots of properties.
Therefore,
My lord.
he is
Even I
depriving.
suggested for any conciliation can be
Yes,
done or
Lordship.
not, my lord. That is also not. They are not agreed, my lord. Not agreed, my lord. That's fine.
I tender my proposal to
My
Mr.
lord.
Bhia
Even
also
I discussed, my lord.
for
No,
any
your
settlement.
party is not.
No, both the parties is
Both
not.
the
my lord.
parties.
I am ready, Your Honor.
No.
My proposal,
Not something is there I cannot disclose.
my
Obliged, my lord.
client.
Even then, in this period, I will again make an attempt, my lord. My lord.
Conciliation too, we always welcome
My
that
lord.
decision, but
Child is there, my lord. That's
child is there.
particularly in this type of cases.
My lord.
In
Otherwise,
this type of cases, and but you see, the child will be more
My-
victimized.
Yes.
He is the actual
He
victim.
is suffering, my lord.
actual victim is the child.
Actual
My-
victim is the child. So we must try
My
if
lord,
it is
we'll
there
try,
is
ma'am.
possibility.
Obliged,
Obliged.
deeply obliged.
Oh, you don't know. It's 39 you are appearing or you 38?
I'm saying 39, man.
You are appearing on 39.
Yes, ma'am.
Malaj, I beg to appear in item 38, Malaj.
You are on 38.
Please, Malaj. Malaj, in fact, in this
So both
matter,
are the
Malaj,
connected matters. Or
Arising out of the same judgment, ma'am.
arising out of
Same judgment, ma'am.
same judgment.
Yes, ma'am. Same case.
Both are the criminal. Your appellant is also behind the bar or what?
All are behind the bar.
All are behind.
All are behind.
You are representing how many?
Mal 4, ma'am.
4.
Yes, ma'am.
And your petitioners are 1 only.
please, Malaj, I am only one
Only
person, item 38, Malaj.
Now see, at this time it may not be possible to hear the matter. And one more thing I just want to say in item number 38, particularly you, is there any possibility to appear personally before the court? Because sometimes it happened that on the last week or 2-3 days back, I think, From Delhi only we are hearing a matter.
Please, my
And
lords.
completely there was no sound at all. He was not at all audible. And then the other counsel who was personally appearing before this court,
Please,
he
my
had to argue the matter. So there are some technical thing that if you can
Mhm.
come, then most probably it will be.
My lords, I apologize, my lords, but my client may not be able to afford, my lords, the travel to Guwahati, my lords. But my
Is
lords,
anyone representing the here in the locally?
yes, there is the local council is there, but she's taken ill today, my lords. Otherwise, there is always one local council here, my lords, to make sure that there is no, my lords, problem in assisting your lordships. But my lords, what I wanted to point out is that, my lords, since December 2025, my lords, the state has been taking time in this matter to file a response. Because, my lords, the conviction is that the appellants have been
Conviction is of how many?
10 years, my lords.
Then do one thing. Why we won't go for I? We'll let the matter be finally disposed of.
Please, my lords, as your lordship pleases, my lords. My lords, we are ready on the suspension of
Have you
sentence.
filed your written objection now by then? Not yet filed because it is a 10 years conviction written, so it has to be there. So we'll do one thing. You get prepare yourself for final hearing on the next date of listing.
Please,
so
madam.
that matter can be finally heard and decided because this today also most probably prosecution has not filed their objection.
Please, madam, this is the 5th date that they've been coming and saying they need time.
Item number 39 will do again for 38 also or what?
Yes, same case, my lord.
All are same. So he is saying, Mr. Borthakur, the additional PP is submitting that in item number 39, the written objection has already been filed. So that will most probably serve the same purpose for the 38 also.
Well, if they
more or
can
less.
serve us in 38, we have no difficulty, my lords, to
Yes. Okay.
just let's
Then
use that. money.
we'll do one thing. Can we be the attractive date? Yes. Mr. Gupta, 21/4 is a Tuesday. That is a hearing day. It can be fixed on that day also. Will it be will be comfortable for you on 20?
Please, my lords, as your lordship pleases, please.
Okay. Okay, we are listing it on 21st of April, and we'll try to hear the whole the appeal only.
Please, my lords.
So that it can be disposed. Okay.
Please, my lords.
21st of April.
My lordship may permit us to file, my lords, a short note for your lordship's convenience, my lords, along with a very concise judgment compilation, my lords.
Very nice, very nice.
Please,
so yes, it can be placed on the next date before the
ma'am.
court.
Please.
We welcome on.
I'm so grateful.
Like need to positive time limit. 21st of April. So we're listing it on 21st of April.
Please,
matters. Okay.
please.
Thank
Deep regret.
Obliged.